Right. Hello, Anand. Good afternoon. You have to unmute.
Anand Grover, sir?
Yes.
Okay. Now, sir can unmute.
Okay.
Yeah, thank you very much. I'm here.
Yeah. Hello, how are you?
Very well. And you?
I'm good. I introduce our Dean and Director, Dr. Madhuri Parikh.
नमस्ते सर.
केम छो? मजामा?
बस हाँ सर.
Wow, that's fantastic.
मैंने गुजराती आवड़ती because I live in Mumbai, so I have to speak
Oh, so-
Gujarati, Marathi,
So-
and Hindi, and Punjabi, and English. So
Wow.
it's lovely. You so cover, madam.
बस. You speak so fluently.
No, I have very close Gujarati friends. You know, even in fact, I argued one matter in Bhuj in the district court. Then I was told you have to argue in Gujarati. So I argued half in Gujarati and half in English because all the judgments were in English.
Right.
So,
Anand, you will have 20 minutes for
Yeah,
us.
I'll try to limit myself.
Yeah, sure.
Tell me about 3 minutes before.
I will do that. Or as soon as Shreya start introducing you, I will upload your presentation. And as soon as she completes her introduction to about you, we will start your presentation.
Oh, I'm sorry, I'm not in formal clothes. I'm in the
That's fine,
Saturday
I
holiday.
suppose. That's fine.
Gagandeep sir, if you
There
could
are no
please.
holidays for lawyers. We have to work
Manvendra
on
sir is
Saturday,
facing
Sunday.
problem.
Manvendra is here. Can you please?
Yes, I did. Yeah.
Yeah, sure.
Sir can now talk.
Hello, Manvendra. You can speak now.
Yeah. I was trying to unmute myself. Yeah. Is it? Am I visible?
You
very
are
visible,
visible, but in a
but you're
vertical manner.
an
So if you can
astronaut.
make it horizontal.
Yeah,
You're
I'm trying to,
you're an
but
astronaut.
Yes, you are
No, you're
horizontal
okay.
now.
You're okay now.
yeah, I'm trying to make it horizontal, but I don't know how it's happening. So
No, it's okay.
No,
Are you
you're okay.
managing with your phone?
yeah, I know it is a tab, but I'm trying to make it horizontal, and it's still coming vertical.
No. This is fine. This is fine.
Vertical is fine.
Vertical is
Yes.
fine. Yes.
Okay.
No, I mean, whatever your position is right now, please
Yeah.
continue with that.
Okay. No, I'm not a very technical person, so I
Yeah,
don't know
that's
how
fine.
to make it vertical. I mean, it's horizontal, and also
Many of us are like,
Yeah.
twice. Right.
yeah, it's
Sure.
fine. If you can manage it, then I'll appreciate.
Yeah. Manvendra, I introduce our Director and Dean, Dr. Madhuri Parikh.
Hello.
Hello.
Yeah. Hello. How are you?
Fine. How are you, sir?
Yeah. Thank you for having us here.
No, good that you have consented.
Hello, Anand. How are you?
How are you?
Yes,
I
I'm
was
great.
telling somebody about you the other day, Manavendra.
Sorry, you
I
are what?
talked to you. I talked to somebody about you
Okay.
a couple of days back.
I
So
see.
I'll talk to you. I'll just talk to you after the meeting today.
Okay, sure. Yeah.
2:45 about something.
Yes,
Okay.
definitely. Yeah. Should I unmute myself till you start, so that you don't get any sound?
Yes, please. Yes, please.
And shall I even put off my video also?
That's fine if you are comfortable with that.
Okay, because it's still time for starting, right? I mean, now
Yes. We are starting the seminar, but your speech will come after almost, say, 45 minutes or so.
Oh, okay. So I'll just unmute and maybe keep my video off so that it will save on the
Yeah, sure.
the battery and all.
Yeah, please do that. Thank you.
I think, ma'am, we'll
Yes.
take 1 minute.
To join.
Because sir is joining,
Sir,
so
yes,
1
yes.
minute. After 1 minute, we can start.
Yeah, sure. Megan, are you there? I take that minute until DG sir joins. Megan?
Yes, I'm here.
Megan,
and-
meet Mr. Anand Grover, Senior Advocate at Supreme Court, and Mr. Manvendra Singh Gohil, another speaker. He's a champion of for rights of LGBTQ, your co-panelists.
Wonderful.
Yeah.
It's fantastic to meet you virtually.
Yeah. Hello, Megan. How are you?
Very well, thanks, Annie. I'm really looking forward to your presentation later today.
Thank you. Yeah.
Please unmute yourself. Anand, you have to unmute yourself.
Good
Anand?
morning, Megan. I imagine it's morning still in South Africa.
Yes, it is
I
9:30.
work very closely with the Treatment Action Group when Mark was there, Mark and other people on access to medicines. So I know all of them very well.
Yeah, that's such important work. It's wonderful to know that you already have some ties with colleagues in South Africa.
I have very close ties. In fact, Justice Edwin Cameron is a very good friend of mine who's retired as the constitutional judge. So I have
Yes.
close friendships with a lot of people in South Africa.
Brilliant.
And Anand and Manvendra, I introduced to Professor Toit and Professor Domingo. Professor Toit, I'm
Good
very
morning.
happy to
morning.
introduce Mr. Anand Grover and Mr. Manvendra Gohil in the first panel.
Good morning.
Yes.
Professor Lloyd and Professor Domingo.
How are you, Professor?
We are well. We're very pleased to be here.
Yeah. Thank you.
I want to say good afternoon to both of you.
Yes.
But I must confess, I'm a part-time professor. I'm an adjunct professor at Georgetown and also a visiting professor at INLU-FLUJ. So I'm part-time a professor, but 90% of the time I'm a professional lawyer. So
But that's fantastic because you bring the law and the I want to say the practice into the classroom, which is very important for our students.
yes,
And,
that's what I think.
and he says he's a part-time
Yeah,
professor, but
that's
he's a
it.
fantastic person when he starts speaking about things. And his involvement on this particular issue is so much that we really
Yes,
look forward to
I
his
heard he said
scholars.
he had links with Justice Cameron and Mark Hayward. I'm assuming, yes, from the treatment. So that's fantastic.
Yes, Mark and Adila Hashim and a
Adila
lot of the
Hassim,
younger
yes.
people also. Yes,
Okay.
Adila, Mark and Edwin are personal friends. I can tell you that Edwin and Justice Kirby used to come here and give lectures to the judiciary on HIV. So I used to be their chaperone, as it
Oh,
were.
that's fantastic. That's
Those were-
lovely.
Yes, in fact, Edwin has written a book partly on this issue, and he talked about it as the caravan. We had a caravan, and I must tell now my Gujarati friends that we actually went to a judge in Surat. That was a very interesting day, but I can't talk about it on
No.
on webinar where it's all open. Things happen which were very unusual. So it's better that I don't. Chatham rules don't apply here, so I have to be very careful. We have the professors from Nirma also. Would you like us to be introduced to them? I can see Dr. Prasad and some
Yes,
other. I
sir.
don't
He's
know.
there with
They're
us.
shifting
He's our
all the time.
area head. And we have Kushal Nandwani, and I think he's already acquainted to you. So
Who is
he's
that?
also Kushal is there. Kushal, can you unmute yourself?
Yeah, and
Sorry,
before
Anand.
that, I would also introduce, I would like you to introduce to Elmarie Fori, Professor Elmarie Fori. Elmarie, are you there? Right.
I am.
You met Mr. Anand Grover and Mr. Manvendra Singh Gohil. They are the speakers
morning.
In the first place. And our DG sir has joined, Professor Anup
Good
Singh.
morning. Good morning.
Good morning. Nice to meet you.
Lovely to meet you too. Lovely to meet you.
Morning.
Professor Anup Singh is our Director General, sir. And sir, I would like to introduce to Professor Toit and Professor Domingo and Professor Fori and Megan Feen, who are part of this collaboration, very actively participating this way.
Great.
Morning.
Good
I want
morning
to say
to
good
all.
afternoon
Good
to
morning,
you,
sir.
Professor Singh.
Nice meeting you.
Good morning,
Nice meeting you.
Professor Anup Singh.
Good morning, sir.
So, sir, with your permission, can we start it?
Yes,
Start
yes,
the
yes.
webinar now? Thank you.
My computer was having some problems, so I was slightly late, but let's begin.
Yeah, sure. Thank you. Shreya?
All right, thank you, ma'am. A very good day to all present today. The Institute of Law, Nirma University, and the Faculty of Law, University of Johannesburg, are delighted to host you at a 4-part seminar series as part of a collaboration project. Before I move on, I would like to introduce all of you to my colleague from University of Johannesburg, Ms. Ropafatso Mafosa, who is Research Scholar at Public International Law, University of Johannesburg. Ms. Mafosa is pursuing her doctorate in Public International Law at the university. She completed her LLB and LLM in Human Rights with distinction in the year 2019. She is currently a researcher at the South African Institute for Advanced Public, Human Rights and International Law at the Center of University of Johannesburg. Her work has been published in prestigious law journals, and it primarily focuses on constitutional and human rights. Thank you, Ms. Mafosa, for collaborating with us on this project. I now request you to introduce our eminent dignitaries.
Thank you so much, Shreya, for that introduction, and welcome everyone to the very first seminar in what is going to be an amazing series in a collaboration between IMA University and the University of Johannesburg. We're so glad that you could join us today. I have the honor of introducing a number of dignitaries this morning, and I hope you'll help me welcome Prof. Anup Singh, the Director General at IMA University. Prof. Singh, over to you.
So I take this opportunity to welcome all the professors and legal experts. So, I mean, in the beginning, I'd not like to say anything. You introduce the speakers, and then, if you want me to share my views, I will do that.
You're welcome to Prof. Singh.
Sure, sir. Thank you.
Professor Singh, actually, we are waiting for your inaugural speech. I will introduce you. Ropa, will you please have a formal introduction of Professor Singh, please, and then invite him for the inaugural speech.
Thank you so much. Shreya, can I just leave that to you? Is that all right?
All right.
Sorry, I'm having problems with my mic. Apologies.
All right. Fine. No problem.
All right. All right. So we have Professor Singh with us. Professor Singh is an eminent academician and a thought leader. Under his leadership since 2013, Nirma University has moved from strength to strength. He did his PhD from the University of Allahabad and postdoctoral fellowship from the University of Michigan, Ann Arbor. He was a visiting scholar at the J.L. Kellogg Graduate School of Business Administration, Northwestern University, Evanston. He has headed 3 educational institutions prior to his present stint, and he has published widely and is a recipient of various awards for teaching excellence. Sir, thank you for joining the seminar, and if you could please deliver the inaugural address.
So thanks a lot. I take this opportunity to welcome my friends from South Africa and legal experts from India and students. This is indeed a wonderful forum where we have experts from two continents sharing their views. Though we may be several thousand miles apart, but there are a lot of issues which are common to us. So it is right that we have come together. I love, this statement of a scholar who says that, the whole world has come out of Africa. So if we look into the evolution of humanity 60,000 years ago, all of us were in Africa, and then we started moving out. We moved into different parts of the world, and though we may look different, we are one, right? And there is historical evidence that these people who moved from Africa, they came to Indian continent around 20,000 years ago. So we have very deep linkages, and we also, share our common concerns. So far, Indian society is concerned, it's a very complex society, just like South African society, right? While we have a very rich civilization, we also have our own societal issues, right? We had a background of colonialism, we had a background of feudalism, we had a background of casteism, right? So while as a civilization we progressed, we also had our own contradictions. Contradictions in terms of religion. I don't think that there is any part of the world where you have got so many religions, right? So we have Hinduism, we have Islam, we have Christianity, we have Jainism, Buddhism, and so many tribal religions. So that diversity, may look simple, but at the operational level, it creates its own contradictions and paradoxes as well as conflicts. Similarly, we have this legacy of casteism and varnashram, and the complexity of the casteist society is that there are caste after caste, and in India we have more 1,000 castes. So every caste has someone to look up and someone to look down, and it is so ingrained that it has created social inequality. So while politically, everybody is same, but socially they are not. And 30 years ago, when we went for economic liberalization, it was a welcome move because it led to rich society, it led to prosperity, but at the same time, it also created layers of inequality. So we are a society, where there is a political equality, but there is a societal inequality, there is economic inequality, there is educational inequality, and then there are smaller groups which have their own identity and their own concerns, right? And society is moving at a pace where the society does not have time for such groups, right? So the kind of legal attention and political attention which such groups might have required, that is not given, right? And I'm sure that some of these difficulties, contradictions, and paradoxes are also visible in South African society. And we would learn about these contradictions and what are the legal protections for these groups. we would be hearing from experts from both groups. So thank you very much. Shreya, you can take over.
Thank you so much, Professor.
If I would like to now introduce Dr. Madhuri Parikh, who is the Director and Dean in Charge at the Institute of Law at Nema University. Dr. Parikh is at present Director and Dean. She has been working at the Institute since 2007. Her areas of interest are environmental law, forest law, legal research, law of torts, and she has researched widely in the field of environment and forest law, where she has published considerably. Dr. Parikh, it's an honor to have you, and I will now hand over to you.
Thank you. Respected Dr. Anup Singh, sir, Director General, Nirma University, Professor Toit, Vice Dean, Research and Internationalization at Faculty of Law, University of Johannesburg, Professor Domingo, Executive Dean, Faculty of Law, University of Johannesburg, Professor Elmary, Professor and Head, Department of Public Law at Johannesburg, Professor Dr. Varsha Ganguly, Professor at Institute of Law, Nirma University, Ms. Megan, Lecturer in the Department of Public Law at the University of Johannesburg, Mr. Anand Grover, Senior Advocate, Supreme Court of India, Mr. Manvendra Singh Gohil, Founder, Lakshya Trust, Champion of LGBTQ, Ms. Leonie, Ms. Shreya, Ms. Mofaza, dear participants from Nirma University and University of Johannesburg and from India and abroad. A very warm welcome to all of you at the seminar series organized by Institute of Law, Nirma University and Faculty of Law, University of Johannesburg. The present seminar series organized in collaboration has been divided in 4 parts. The first part of it, that is the present seminar, is scheduled today, which is focusing on mainly 2 issues: the rights and realities of the LGBTQ community and the commitments to CEDAW. So elimination of discrimination against women, that is the another issue that is going to be discussed along with LGBTQ. Both the topics have been received have received unprecedented attention at the international level, and now there is a growing concern regarding the liability of the state on these issues. And the if we see, it is a matter which is discussed and deliberated upon uniformly at in all the states in the present era. And the human rights of LGBT are coming into sharper focus around the world, with important advances in many countries in recent years, including the adoption of new legal protection. If we talk of India, the preamble to the Indian Constitution mandates justice, social, economic, and political equality of status for all. But there is a gap in the law and the practice that we have seen. The right of equality before law and equal protection under law is also guaranteed under the Indian Constitution. And if we make a comparative analysis of India and Africa, even in Africa, the same kind of, you can say, the protection of law is available. The Supreme Court recently, the Supreme Court of India also observed that the rights of freedoms of transgender people in India were protected under the Constitution, particularly in the Nalsa judgment. This has been emphasized. Similarly, the Supreme Court also decriminalized adult consensual same-sex relationship in that is in section 377 judgment review. These judgments are considered a landmark both in terms of their expansive reading of constitutional right and in empowering LGBT persons. This was a welcome victory, but it does not necessarily mean that LGBT people in India are fully free or perceived as equal among their fellow citizens. There are many concerns. The concerns, social concerns. There are issues related to social acceptance, legal acceptance. Even if there is a legal acceptance, whether there will be social acceptance, because there is diversity in the culture at the acceptance level of this, the rights about this particular group of people. So the present seminar will be very helpful in understanding the comparative perspectives of 2 issues that is from the angle of the legal framework in India and Africa. These two issues of LGBTQ and the commitment to CEDAW for elimination of all forms of discrimination against women. And I think the discussion on this too will be helpful to us in understanding these issues in a better manner with the social acceptance, legal acceptance, and the concerns and the way forward. So once again, I welcome you all to this seminar and hope for long academic collaboration with Faculty of Law, University of Johannesburg. And I also express my sincere thanks to Professor Dr. Purvi Pokharial, who is at present in a dean in National Forensic Science Law Institute, and Professor M. Betty, with their efforts, this and their initiative, this seminar was shaped. And thank you all to be instrument in shaping this event. And I hope that this collaboration will be long beyond it, and it will be also, we may also see the future prospects of student action and many other research action. And I also express my sincere thanks to all the expert speakers who have consented to be part of this discussion today. And I hope that it will be a very meaningful for us in understanding these issues in a better manner. Thank you. Over to you, Shreya.
Thank you so much, ma'am. Ms. Mafosa, if you could continue, please.
Absolutely. Thank you. Thank you so much, Shreya, and thank you, Dr. Parikh, for your introduction. I would now like to introduce the Vice Dean for the Research and Internalization at the Faculty of Law, University of Johannesburg, Professor Cyril du Toit. Professor du Toit is a professor in mercantile law. His research interests include negotiable instruments, banking law, financial law, and property law. In 2008, he delivered his inaugural address dealing with the dematerialization of money and the lingering influence of the law of things at the University of Johannesburg. Professor du Toit studied at the former Rand Afrikaans University, where he obtained his BA and LLB degrees. He completed his LLD thesis also at RAU on bills of lading in South African law, under the supervision of Judge F.R. Malin. Professor du Toit, it's an honor to have you, and I'll now hand over to you.
Thank you, Professor Singh, Nirma University, Dr. Parikh, Dean of the Institute of Law, Professor Ganguly, colleagues from Nirma University and the University of Johannesburg, and of course also dear students. From my side as Vice Dean for Research and Internationalization at UJ, I also wish to welcome you at the seminar today. Let me start by saying what a privilege and an honor it is to be part of this collaboration with Nirma University, and indeed to be associated with Nirma University. Where I'm sitting in the western side of Johannesburg at the moment, looking out of the window, it looks to be an overcast day. It's spring here in our country, and we are all anxiously awaiting the first summer rains to sort of wash away the dust of winter. On my little cell phone app, it doesn't seem like we will have rain today, but perhaps you will hear thunderstorms in the background and some rain, and that should be a good sign. Ladies and gentlemen, on a more serious note, equality and anti-discrimination law in our countries is a theme that's reverberating not only in our countries but across the world. And the project, and more specifically the solutions offered by a seminar such as the one we have today, really seem to be needed more than ever. I always hesitate to single out any persons in a project like this, but I do want to thank Professor Ganguly for her involvement. And on the side of the University of Johannesburg, I wish to thank, I hope you will allow me to thank Professor Elmarie Fourie for leading it from our side as the head of department, and also Megan Finn, who was the driving force behind much of this. But I do know that many people were involved in this project. My wish is that this collaboration, off to such a good start already, will lead to even further projects, partnerships, and especially friendships in the coming years. And I do hope that we will meet each other in person, maybe next year, or hopefully not too soon after that. With that, I wish to thank everyone involved in making these seminars possible again, and I do look forward to the presentations and discussions to come. Ropa, apologies, but will you introduce Prof. Wessel, or should I quickly do that?
You're welcome to, but I'm also happy to.
Let me leave it to you. Thank you, ladies and gentlemen.
Thank you so much, Prof. Dutoy. So I now have the privilege of introducing our newly appointed Dean at the Faculty of Law, University of Johannesburg, Prof. Domingo. She was the previous head of school at the University of Witwatersrand. She holds a Bachelor of Science degree with a major in sociology from the University of Cape Town and a Bachelor of Law degree from the University of the Western Cape. She also holds a master's degree from Columbia University and a Doctor of Juridical Science degree from the University of Wisconsin-Madison. After graduating with her LLM degree, Prof. Domingo interned at the Center for Strategic and International Studies in Washington, D.C. She was also invited by Senator Paul Stross, Shadow Senator of D.C., to work at his congressional office as a legislative aide. Prof. Domingo's teaching and research interests include family law, child law, succession, gender studies, legal education, and legal pluralism. She has presented her work at conferences throughout the world, including Malaysia, Indonesia, Hawaii, Boston, New York, and Seattle. She has made several appearances on television and radio as an academic expert in the fields of family law and legal pluralism. Prof. Domingo is also an accredited family mediator and does family law mediation training, focusing on different cultures and religion for NGOs. She also runs community workshops for women on culture and religion within marriage and divorce. Prof. Domingo was an editor for the South African Journal of Human Rights for 10 years, and in October 2018, she was appointed by the president to serve on the South African Law Reform Commission as a commissioner. Prof. Domingo is also the president of the South African Law Deans Association. Prof. Domingo, it is my honor to introduce you, and over to you.
Thank you for that introduction. Director General Professor Singh, fellow Dean Dr. Parikh, and my Vice Dean Professor Dutoit, to all our speakers here today, colleagues and friends from the University of Nirma and the University of Johannesburg, and to our students, and to those in India, good afternoon, to those in South Africa, good morning. On behalf of the Faculty of Law at UJ, I welcome you to the first part seminar, as we've said, in a 4-part collaborative between the Institute of Law, Nirma University, and the Faculty of Law at the University of Johannesburg. And the theme of this collaboration is Social Justice Continuum in a Comparative Context, India and South African Perspectives on Equality, Labor Law, and legal education. And so, as Professor Singh has said, India and South Africa draw parallels of inequalities and injustices from socio-cultural and political histories of discrimination. We too were colonized, and so decolonialization and decolonization is very important to us in South Africa. We have the pattern of economic development and deprivation of the marginalized section and disadvantaged status due to lagging on developmental indicators such as education, employment, control of sources of livelihood. So those are parallels and things that happen both within, I would say, India and South Africa. So Professor Singh highlighted that we have that in India, you have political equality. We have the same in South Africa. We have a constitutional democracy right now, but we still have socioeconomic education. And I want to say, when it comes to access to justice, access to healthcare, we have inequality. So we too are a multicultural country in terms of religion. And as my CV was read out, you will see I'm very passionate about legal pluralism and family law in the context of religion and culture. So we share that in common as well. In both contexts, legal education is a possible tool to access formal justice delivery. And so I'm excited also in regard to our upcoming seminars to see what those shared parallels are between our countries. I look forward to the seminar discussions. And as we begin our first seminar today, we are indeed delighted to be part of this collaboration where we can bring together scholars from Africa and India to address these global challenges. But most importantly, too, we can bring together students. And I often say our students are the future as well. So without further ado, I'm going to say thank you. I have said to the program directors and the organizers that I have to leave a little earlier today. There are commitments as an executive dean. I have to go and say a farewell at another webinar series, but I will look forward to the engagements, the upcoming seminars, and we hope that this will culminate in a book project. So thank you very much.
Thank you so much, Prof. Domingo. Shreya, over to you.
Thank you, Rupa. Thank you, Professor Singh, Professor Parekh, Professor Toit, and Professor Domingo. Before we move on and start the technical sessions, I would like to show you all a glimpse of life at INLU. Gagandeep sir, please. Thank you.
Welcome to the Institute of Law, Nirma University. The Institute, with its energetic and creative learning environment, is at the forefront of the changing legal education scenario in India. Its vision is to promote excellence in the field of legal education and through this advance human dignity, social welfare, and justice. The curriculum at the Institute of Law is novel, innovative, and designed to keep students equipped and updated with the skills needed in the profession. The innovative justice-based curriculum enables the students to develop a multidisciplinary approach to law, in the sense that law and other behavioral sciences are seen to be interrelated and exist in mutually beneficial interaction. The Institute of Law has set up 7 centers of research and excellence. At INLU, students benefit from expertise of the faculty members in a broad array of legal subjects who are involved in teaching and research. INLU faculty employ a combination of pedagogical techniques in order to provide a learning environment which can challenge learners with different abilities and also encourage self-learning. INLU has a state-of-art library, separate reading room facilities, separate moot court discussion room, and a state-of-art moot court hall, which is equipped with all the modern facilities to give real-life experience of mooting to the students. From the first year itself, students are imparted mooting skills through orientation workshop, followed by intra-moot court competition. INLU has a well-defined moot policy, which facilitates and encourages mooting. Students enthusiastically participate in and have got laurels in prestigious national and international moot court competitions. The Institute emphasizes on academic excellence as well as timely application of legal knowledge through permanent legal aid clinic at Sabarmati Jail. Students have organized legal awareness camps, participated in Lok Adalats, provided assistance in resolving disputes, encouraged people to opt for alternative dispute mechanism. Apart from the competent and dedicated faculty, INLU students have benefited from the distinguished experience and expertise of renowned dignitaries and legends in law, who visit our institute and guide, influence, motivate, and inspire our future lawyers. INLU believes in all-round development of students. This is facilitated by a number of committees and clubs at the institute, who conduct a wide range of extracurricular activities. The objective is to channelize and explore the hidden potential among students. On successful completion of the program, the Institute assists the students in exploring placement opportunities by inviting companies for campus recruitment. The Institute has a well-established campus recruitment cell to facilitate this. Institute of Law endeavors to provide quality legal education and all-round development of its students. It endeavors to treat every student as an individual, to recognize their potential and to ensure that they receive the best preparation and training for achieving their career ambitions and life goals. INLU addresses a rapidly changing world filled with new problems as well as exciting and endless possibilities. With innovation, excellence, and quality being the driving forces, the Institute of Law at Nirma University holds a promise to a shining and better future.
Thank you so much, sir. Before we start, introductions are must for the audience of my colleagues who have been seminal in shaping today's seminar. I would first like to introduce Professor Elmarie Fourie. Professor Fourie is a professor at the Faculty of Law and head of the Department of Public Law at the University of Johannesburg. Currently, she is the program coordinator for LLM in labor law and lectures labor law to the undergraduate students as well as the postgraduate students. Professor Fourie was awarded a Vice Chancellor's Distinguished Award for Teaching and Excellence in 2010. She has been part of various task teams preparing legal opinions to government departments and drafting legislation for the South African Development Community countries. These have been on solutions to extend labor law and social protection to vulnerable women workers in the informal economy. Professor Fourie has also published on labor law, social protection, and legal education in national and international journals. Professor Fourie, I would now request you to kindly address the gathering.
Thank you so much. Good morning, ladies and gentlemen, and what a wonderful privilege to be here today and to be part of this collaboration. After months of meetings and planning, we are so excited to host and take part in our first seminar. And the seminar is so important on equality and anti-discrimination law. Our collaboration is of particular importance to us. Why? Because we represent two countries with histories of colonialism, structural injustice, and inequalities in a contextual framework that promotes transformative constitutionalism, even if it's only on paper. Apart from the topic today, the other topics in our seminar series also include challenges that our two countries face, specifically with reference to the changing notion of the world of work and the high number of workers in the informal economy. And this is something I'm particularly passionate about, and we really hope to learn lessons from India, where more than 90% of your workers are in the informal economy. And in South Africa, they represent previously disadvantaged workers and specifically women workers. So we're really looking forward to this collaboration. And we will also consider the impact of climate change on specifically vulnerable groups such as migrants. During our discussions, we have also identified similar challenges with reference to legal education and specific issues that both universities face. For example, the high number of first-generation students and the challenges that this poses for us, and the challenges with reference to social justice. Lastly, we will consider the role of emerging technologies, and this presentation will consider the interaction between positive contributions that these tools can make and the attainment of social justice. Why is this collaboration so important? It's a comparative study, a comparative analysis, and we want to learn lessons so we can improve and we can work to this just society of equality, freedom, and human dignity for all. Throughout the seminars, the importance of social justice will be highlighted. And I just lastly want to support something that Prof. Du Toit said. We started out as colleagues, and I feel that I've become friends with many of you, and that is so valuable. And I really hope to meet you all. Thank you for everything, all the hard work. Really looking forward to this. Thank you so much.
Thank you, Professor Fori, for those warm words. At the Institute of Law, I would like to introduce all of you to Professor Varsha Ganguly, who is a professor here and has worked prior with two premier institutions. Professor Ganguly was previously associated with Lal Bahadur Shastri National Academy of Administration at Missouri and with the Indian Institute of Advanced Studies, Shimla, as a professor and a fellow, respectively. Professor Ganguly is actively engaged into versatile use of research, including teaching, enhancing a cycle of social knowledge and social transformation, and people's knowledge based upon ground-up public policy. Professor Ganguly is on the advisory boards of a couple of networks and philanthropic organizations working on women and land rights. Professor Ganguly has also published widely on land rights and land questions, citizens' rights and collective actions, and on the marginalized groups in India, and has also been an editor of 3 academic journals. Professor Ganguly, if you could please address the gathering.
Thank you, Shreya, and I again warmly welcome all of you. It is truly a very privilege, and the journey is almost 6 months long. When we started with Professor Empedi and Professor Purvi Pokharial, and we started thinking about the collaboration, we eventually, a series of meetings and discussions, we realized that social justice is one of the themes which really is providing us a ground for comparative context. And my predecessors have really spoken so well about it. And so therefore, I'm not repeating it. In continuity to what Professor Fori said, and in as a complementary to her speech, basically the comparative context, and it's not just two countries, but we represent different two regions as well, and those regions comparison is equally important to us in the context of not just social justice but formative constitutionalism, and how to I mean, our academic contribution would be to look at the structural injustice and explore avenues for social justice. One of the major consideration in forming and selection of those themes were, one is, of course, the kind of typical norms of social justice, but we wanted to explore not just in terms of much known discourse on caste and multi-religion and race and gender, and of course all of those. So with due respect to this inequalities, we started thinking about new challenges that are coming in terms of coming up in terms of social justice, and that's where we started thinking about sexual orientation, concerns of family, and family has been family, marriage. These are the classic institutions that we all look at the society and in understanding the inequality. And that's how we have started identifying as far labor theme is concerned, and we started thinking about the climate change as a larger challenge, and the vulnerability of migrants, especially in Indian context and across South Africa. The recent, I mean, in neoliberal period, neoliberal era, the kind of labor law reform that we have witnessed and the kind of informalization which is increasing, the challenge of automation and use of digital technology has also been considered in developing the theme and linked to the social justice theme. The concept of social justice. So these are the highlights of it. And similarly, we also realize that legal education in neoliberal era, we need to talk about earlier. It has been largely legal education has been talking about the discourse is shaped up from the educatee and educator perspectives. And we realize that we really need to look at this existing discourse from social justice perspective, and in which we are going to sort of now talk about pitfalls and perils of legal education in the neoliberal era, along with the importance of ethics and foundational education and idea of CHAM, that is creative, holistic, and looking at the adult andragogy pedagogy kind of thing. And the last theme of law and technology that we have developed, I think the most important part of this theme is that from both the countries, from India, we are articulating the concerns of social exclusion by using the law and technology and the technological advancement, while from South African perspective, we are looking at how the digital use of digital technology can be social inclusive. And so that's how we have started. The presentation can now make it very clear that we have tried to be complementary to each other in each and every aspect, and we have really deliberated, tried to deliberate every possible avenue that we can cover, with opening up from academia, researcher, social actors, law practitioners, and so on. And we will be sort of inviting all of them, and this kind of variety of presenters will definitely provide us every discourse from different perspectives, and that would be a greater exposure, not only in comparative context, but also coming up with probably policy documents and interventions, as many of us are involved in that. That opens up a lot of research areas and scope for that. And as my respective eminent panelists have said, that we are really looking forward to the continuation of this collaboration, not only in teaching, but research and other areas. We all are truly very looking forward to continuity of this collaboration and the series of present collaboration, the 4 series of webinars. Thank you all the office bearers for providing us to take this collaboration ahead with its true spirit of education, research, policy, and all other possible areas for academic contribution. Thank you all, and I again warmly welcome you to in the first webinar of this collaboration project. Thank you, Shreya.
Thank you so much, Dr. Ganguly. And thank you for the overview of this seminar series that you have provided. With this, I believe we are now going to start with the technical session, the first technical session for today. The first panel is on the legal rights and the realities of the LGBTQI+ community. It examines the legal advances in securing the LGBTQI+ rights on paper, the gaping disjuncture between law and lived realities, and the role played by state and non-state actors in both jurisdictions, India and South Africa. I would now take the opportunity to introduce the eminent panel to our audience. Our first speaker today is Megan Finn. She is lecturer at Department of Public Law, University of Johannesburg. Ms. Finn is associated with the University of Johannesburg and is also an editor of Constitutional Court Review. Ms. Finn holds Bachelor's in Social Science Honors and LLB degrees from the University of Cape Town, and a BCL degree from the University of Oxford. Currently, Ms. Finn is a PhD candidate at the University of Witwatersrand. Ms. Finn served as a law clerk of the Constitutional Court and is an admitted advocate of the High Court of South Africa. Ms. Finn previously practiced at the Johannesburg Bar and has appeared as counsel in a number of reported judgments, including that of the Constitutional Court. Thank you, Ms. Megan Finn, to be a part of this panel. I would now like to introduce our second panelist, Mr. Anand Grover, Senior Advocate, Supreme Court of India. Mr. Grover is a designated senior lawyer practicing in the Supreme Court of India and the director of the Lawyers Collective. He is known as a passionate advocate and an activist on HIV, right to health, and human rights. Mr. Grover was the United Nations Special Rapporteur on Human Rights Council and worked extensively on the right to health from 2008 to 2014. During his time as the UN Special Rapporteur, he focused his reports to promote non-discrimination and empower vulnerable groups and ensure meaningful participation of affected communities. Mr. Grover has been an active advocate for several trend-setting legal cases and judgments related to rights of the LGBTQI+ community in India. Thank you, sir, for being a part of the panel today. I would now like to introduce Mr. Manvendra Singh Gohil, who is founder of INLU-FLUJ Trust and champion of LGBTQI+ community in India. Mr. Gohil is founder member of the INLU-FLUJ Trust, which is a community-based organization working for HIV and AIDS prevention among men who have sex with men. INLU-FLUJ has won the Civil Society Award 2006 for its contribution in preventing HIV/AIDS among homosexual men. He has also worked with Asia Pacific Coalition on Male Sexual Health, which is one of the best mediums to bring together different nationalities and develop linkages with others working for HIV and MSM or the transgender community. Mr. Gohil has spoken about his sexual orientation publicly in the year 2006. He has appeared as a guest on the Oprah Winfrey Show for 3 times since 2007, and he is an accepted champion of the LGBTQI community across the country as well as internationally. Thank you, sir, for being a part of the panel. With this, we now begin our technical session, and I request Ms. Megan Finn to begin her presentation.
Fantastic. Thank you so much, Shreya. I hope you can see my screen, which I have just shared. It should be appearing on your screens now. Are you able to see that?
Yes, we are able to see it, Megan.
Okay, wonderful. So thank you so much, colleagues, friends, and students for joining us today. I'm really excited about this collaboration in today's seminar, and it's an absolute privilege to be here to learn from fellow panelists today and indeed from all participants in today's session. So I'm going to start off my talk today with a scenario. A church fires one of its employees when he comes out as being gay and in a relationship with another man. The church cites its religious doctrines, which prohibit same-sex relationships, and states that its freedom of religion and association rights render its decisions lawful. What do we make of this? Is this unfair discrimination that is prohibited by law? Is it relevant whether the employee is, say, a musician who is part of the church band and does not actively take part in any spiritual or religious instruction? Would our intuitions differ if instead the employee were a religious leader? And how should the law resolve the clash between equality rights on the one hand and freedom of religion on the other? These are the central questions I will be grappling with today in my presentation. South Africa's constitution is the first to expressly prohibit unfair discrimination on the grounds of sexual orientation, representing a massive legal and political victory for LGBTQI+ rights. At least in theory, LGBTQI+ communities in South Africa are guaranteed legal protection, including in the recognition of relationships and family forms, and in access to state, public, and private services. Section 9(4) of the Constitution makes it clear that not only the state, but all persons, including private persons, are prohibited from discriminating unfairly against persons on the grounds of sexual orientation. Against this backdrop, how should we understand South Africa's imposition of a legal duty on private persons, including religious organizations, prohibiting unfair discrimination on the grounds of sexual orientation? Just to provide a bit of an overview for what I'll be discussing today, I will begin with a brief discussion of how South African courts have understood substantive equality. I then turn to explain the formal legal gains of LGBTQI+ communities in South Africa, and I've been keenly following similar progress in India in the recent Navchev Johar and Sushma versus Commissioner of Police judgments. I'm really looking forward to learning from my colleagues in India's experiences in advocating for LGBTQI+ rights. I then turn to the disjuncture between these formal legal victories on paper and lived realities of queer communities in South Africa. Next, and against the backdrop of South Africa's commitment to substantive equality and the on-the-ground challenges to achieving equality in practice, I consider how LGBTQI+ rights not to be discriminated against play out in the private sphere. As a case study, I consider the clash of these rights with freedom of religion. Finally, I raise some open questions in South African law, which in turn raise questions about the role that law can play in securing meaningful social change. What kind of conception of equality is endorsed in South Africa? Well, South Africa is persistently positioned as one of the most unequal countries in the world. For centuries, the state and the structure of society more generally legitimized discrimination of the most stark, pernicious forms. At least on some measures, inequality in South Africa has increased since apartheid's end, notwithstanding declining poverty levels. The devastating consequences of COVID-19 have only exacerbated this. In 1996, South Africa's constitution was put in place. And the constitution includes the right to equality and not to be discriminated against on the basis of a number of grounds. In terms of jurisprudence, South African law has endorsed substantive equality rather than formal equality as the core conception of equality. Formal equality, or equality as consistency, requires that individuals in like situations or circumstances are treated alike. As a comprehensive equality norm, formal equality is questionable. It presumes that the background or default distribution of rights and goods is just, and that what equality requires is equal treatment only. This fails to account for existing disadvantage and structural or systemic inequality, which often requires difference in treatment. Substantive equality, conversely, is responsive to existing systemic inequalities and requires that these be dismantled. In part for this reason, substantive equality requires a context-sensitive and historically rooted approach. Further, and unlike formal equality, substantive equality is more outcomes-oriented and treatment-driven. It demands that existing structures of discrimination must be dismantled. And relevant to today's presentation, those structures can exist both in the state and also in private spheres. As mentioned, South Africa's constitution is the first globally to entrench LGBTQI+ equality. And this was a result of extensive negotiations during the transition from apartheid to democracy, and a full-bodied commitment on the part of the ruling party to same-sex rights, which was noteworthy, especially at the time. And of course, as a result of the tireless advocacy of prominent queer activist groups. This express constitutional protection led to a decade of legal victories for the LGBTQI+ community in the early post-apartheid years. And the link below on the slide is really provides some kind of historical overview if anyone is interested in following that. The victories that were made, the legal victories, took a gradualist approach, beginning with very winnable objectives, such as decriminalization of sex, and then moving to express recognition of family and partnership rights. Major early victories include the National Coalition for Gay and Lesbian Equality judgment, where the constitutionality of laws that criminalize sodomy was successfully challenged. There, the Constitutional Court found that criminalization of sexual activity profoundly infringed the dignity of gay men. Next is the Satchwell and NCGLE judgments, which recognized the rights of same-sex life partnerships. Then the Toy judgment and the J judgment, which recognized the right to family life for LGBTQI+ people, including adoption rights, and parental rights of a lesbian couple in respect of artificial insemination. And then finally, the recognition of same-sex marriage in the FLUJ judgment and subsequently legislated in the Civil Union Act. The Civil Union Act is somewhat controversial because while it recognizes same-sex marriage, it effectively does so by creating a separate legal regime. Those were the flagship legal victories secured in the first 10 years of democracy. And there are two significant developments to draw attention to in addition that are ongoing now. The first is a burgeoning recognition of transgender rights in a number of judgments across different areas, such as discrimination in the context of the state's duties within a prison context. Though here, South Africa is still lagging and the actual protections that are afforded are somewhat insufficient. And the second recent development is the Kwelane judgment. It's a very recent legal gain for LGBTQI+ rights in South Africa. Effectively there, a journalist and former ambassador published a newspaper article titled "Call Me Names, but Gay is Not Okay." The article argued that homosexuality is unnatural and compared same-sex marriage to bestiality. It was met with a large public outcry, and he was sued on the basis that his article constituted hate speech on the grounds of sexual orientation. Ultimately, the Constitutional Court unanimously found that Mr. Kwelane's article was hate speech. The court castigated his article in strong terms, calling it abhorrent and noting that it constitutes vilification of LGBTQI+ people. The court recognizes the psychological trauma suffered by the LGBTQI+ community and the relevant context when the article was published, which was characterized by an extraordinarily high level of violence against LGBTQI+ community in South Africa. And this really brings me to the next overall point to make, which is a large disjuncture between the formal legal protections that are expressly available and that I've just discussed and the reality on the ground. While the Constitution prohibits discrimination on the ground of sexual orientation, the lived realities of those marginalized on the basis of sexual orientation and gender starkly betrays this promise. LGBTQI+ people continue to experience severe physical and psychological violence, including at the hands of state officials. Homophobic attitudes remain widespread and are often held and enacted by state officials. And hate crimes are yet to be expressly prohibited and regulated in South Africa's legal landscape, although there is currently a bill under discussion to do so. The scourge of homophobic victimization and violence, assault and murder remains a shocking reality in South Africa. And this includes a prevalence of so-called corrective rapes perpetrated by men who believe that they are correcting women's sexual orientations. And since 2000, almost 40 women have been murdered because of their sexual orientation. And in the early 2010s, gay men in South Africa were targeted by a gang of serial killers. And of course, this violence and marginalization occurs on an intersectional basis. Different axes of identity, such as gender, race, and socioeconomic status interact, compounding the disadvantage experienced by individual LGBTQI+ persons. Against this backdrop, how should we understand South Africa's imposition of a legal duty on private persons, including religious organizations, prohibiting unfair discrimination on the grounds of sexual orientation? To what extent does a right to equality, and specifically the right not to be discriminated against unfairly, give rise to duties that are borne by private persons in South African law? Historically, constitutions are usually understood as governing the vertical relationship between subject and state, rather than among private persons horizontally. But South Africa's constitution is a departure from this. Rights can be enforced against private persons, not just the state, in certain circumstances. And this is particularly true in respect of the right not to be discriminated against unfairly. Many other jurisdictions might impose a duty on non-state or private actors not to discriminate, but usually this is limited to private persons who operate in particular spheres of activity, such as employment or housing. For example, my understanding is that the Indian Constitution includes Article 15(2), which also prohibits private discrimination in certain contexts, such as accessing shops, hotels, and using certain public amenities such as wells and roads. South Africa's Constitution, in Section 9, imposes the anti-discrimination duty on the state and all persons, and does not limit the scope. South Africa's equality legislation similarly echoes this. Neither the state nor any person may unfairly discriminate against any other person. We have seen in recent judgments in South African law that courts are open to imposing this anti-discrimination duty on private persons, even in very private spheres. That is, even in respects that are intensely personal. Earlier this year, for example, the Constitutional Court found that a private person could not discriminate in a private will, for example, by stipulating that only male children and not female children could inherit. That would be unlawful discrimination. But unlike the state, private persons bear rights, and so justifying discrimination by private persons as opposed to by the state might be easier. South Africa prohibits only unfair discrimination, so some forms of discrimination could notionally be fair and thus justified. And this is exactly because private persons have claims to constitutional rights, and so leads to the idea that the court may need to balance competing rights of private persons. But how should this balance work in practice? When would discrimination be fair, and what kinds of justifications could a private person raise? A pressure point in South African jurisprudential doctrine to date is the clash between the right to equality, in particular the right not to be discriminated against on the grounds of sexual orientation, and the right to freedom of religion and related associative rights. How to resolve this tension is somewhat open in our law, and in the context of religious associations, it is further complicated by what is known as the doctrine of entanglement, which is really a reluctance of the court to become involved in doctrinal disputes of a religious character. Academic commentators, too, in South Africa are sharply divided on how this balance should be struck. I'll briefly discuss a few court judgments. So first is Minister of Home Affairs versus Fourie, which I mentioned earlier. It's South Africa's judgment on same-sex marriage. In that judgment, the Constitutional Court rejected the argument raised by some religious groups that the state should not recognize same-sex marriage on the basis that doing so would impair freedom of religion. The court said that religious sentiments of some cannot be a guide to the constitutional rights of others. But this was a relatively easy balance for the court to strike. It did not require a religious entity to actively recognize or ordain same-sex marriages. It only required the state to do so. More difficult, however, is where freedom of religion and the right to associate operates in tension with the right to equality in circumstances which require a religious institution to actively afford recognition to same-sex persons. I now turn to the scenario that I opened today's talk with. And really, there are three relevant cases here. The first is the Strydom case. There, a gay music teacher working as an independent contractor in the church's cultural academy, and the church, on finding out that he was gay, ended his contract. He sued the church. He argued this was unfair discrimination, and the Equality Court agreed. It reasoned that he did not occupy a position of spiritual leadership and was not required to teach Christian doctrine. The impact on freedom of religion then was minimal, and this was weighed against the enormous impact that the discrimination had on his rights to equality and dignity. Next is the De Lange judgment, where the answer is less clear. A church dismissed a lesbian minister who did occupy a position of spiritual leadership following the announcement of her engagement to a woman. For obvious reasons, this is a harder case. It was litigated all the way to South Africa's Constitutional Court, but ultimately the court sidestepped the core issue and decided the case on procedural grounds only. A later case in the High Court involving a decision by a governing body of one of South Africa's largest Christian denominations, the Dutch Reformed Church, the body there had reversed its recognition of same-sex civil unions. The High Court
Megan, we have lost your connection. Megan?
Varsha, I will WhatsApp her quickly. I can't.
Yeah, kindly, please.
Megan, can you please unmute yourself?
Yes.
Hi, so sorry about that. My connection just dropped unexpectedly there, mid-sentence. Can you hear me now? I will share my screen. Sorry about that. So really what I was saying was that commentators were really divided. Some argue that diversity of views should be protected and that religious organizations should be able to discriminate. And others argue exactly because of South Africa's extensive history of state-sanctioned and systemic discrimination, that the balance should fall on the side of equality. One of the questions that all of this really raises is the extent to which law can act as a lever for meaningful social change. And that's a theme that's going to be cutting through the 4 seminar series that we've planned. Here, there's some tensions in how we understand this. On the one hand, we've seen in the history of queer litigation in South Africa that some really significant legal developments have been won, and hard won. That's no small thing. It means, in concrete terms, for example, that my civil union with my female partner is legally recognized and protected. That if we choose to have a child together, both of us will be entitled to be recognized as that child's legal parent. That if we go on holiday together, we can't be turned away by a hotel on the ground of our sexual orientation. And we cannot be dismissed from our jobs for disclosing our sexual orientation. But as we saw earlier, there's still a massive gap between what the law protects on paper and, say, my ability to access those protections, given my position as a queer, middle-class, white South African, versus a reality for many LGBTQI+ people in South Africa, particularly accounting for intersectional disadvantage. This reveals that the formal recognition-based legal victories don't always translate to changed lived realities on the ground, particularly in the context of escalating violence and victimization of queer communities. And this is pertinent for how we think about the clash between the right to equality on the one hand and the right to freedom of religion on the other. As discussed earlier, South Africa's anti-discrimination duty is very broadly extended, and the law is committed to substantive equality. South Africa's equality legislation even envisages that for equality to be achieved, what is needed is broad-scale shifts in the hearts and minds of all social actors, that the social structures, practices, and attitudes in which discrimination and inequality are deeply embedded must change. But the law is an imperfect, even blunt tool for securing this change. And there's a serious tension between, to borrow a recent phrase from the Indian Supreme Court, constitutional morality and popular morality. These questions are still open and unresolved, and they are profound, with very real consequences. I'd be so grateful to hear your thoughts, especially from a comparative perspective, on how the right balance should be struck, and more broadly, on the role and limits of the law. Thank you very much. I'll stop sharing my screen now, and I really look forward to hearing from the other panelists on their perspectives in an Indian context.
Thank you, Megan, for that insightful presentation. I would now request Mr. Anand Grover to proceed with his presentation.
Shreya, will you be?
I have uploaded it.
We are navigating it, sir.
Okay. Just a few preliminary remarks, because I think in the context of what Megan has said, I need to make clear a couple of things. First of all, the Indian Constitution has fundamental rights in Chapter 3, which are akin to civil and political rights, and Chapter 4, which are akin to economic, social, and cultural rights. Only Chapter 3 fundamental rights are actually enforceable, but they are enforceable only against the state institutions. So for the private sector, the fundamental rights are not applicable. In order to make sure that, say that anti-discrimination and equality provisions are applicable, you have to have a law. And I'll explain that, like we've had in the HIV Act and also in the Transgender Act. But I want to, for my South African friends, I'm sorry I'm not actually going into thanking each one of them because we have limited time. We are over short time. So next slide. What I want to tell you is that India is unique in one sense that historically we never had any kind of discrimination against same-sex relationships. So in ancient India, that's much long ago, very long ago, there was very strong traditions of what we call the third sex. And in Sanskrit is Tritiya Prakriti or Napamska, where a person was considered neither to be a man or a woman, because a man may castrate himself and then he would not be a man, but would not be able to bear and beget children. Therefore, he would not be a woman. And in any event, that person who is actually assigned his gender to a woman would not menstruate. So the absence of procreative ability and menstruation did not make him or her a woman. So they were of a different sect. In terms of gender, they were a third gender. And this is historically part of our culture. This is clearly enunciated in the Vedic and Puranic literature, as well as Hindus and Buddhist and Jain traditions. Next. The difference between, let me put it this way, between the Hindu and Buddhist and Jain is the Hindu and Buddhist tradition basically understood the third gender in physical terms, whereas the Jain tradition and very elaborately understood it in psychological terms, which is a huge leap in those ancient days. Even in the Mughal period and medieval India, even the Mughals, contrary to most people's understandings, the Mughals, the Muslims, also treated persons of third gender with equality, as it were. From the Ottoman Empire to the Mughal Empire, they occupied very, very important positions. The last Mughal, Bahadur Shah Zafar's chief executive officer was in fact a transgender person. Even the word transgender is actually of European import. We had our own traditions. So what has to be emphasized is right up to the time that the British came and imposed their cultural traditions through formal law. It was in 1861 through the Indian Penal Code. But in India, historically, gender was not a binary construct. Hijras never viewed themselves as women, neither did they consider themselves as men. So next slide, please. Now, what happened was East India Company actually ruled India for a very long period of time, from the 15th century through the Charter of the Queen till the 19th century. And after we lost our first war of independence in 1857, the British imposed the Indian Penal Code. What they brought with them in the Indian Penal Code was the tradition against the Christian Judaic tradition of actually not considering same-sex relations as normal relations. So they imported into the Indian Penal Code unnatural sex as a category. And the Section 377's marginal title is in fact unnatural sex. So that was imported. I'm not getting into details about that. And what it said was very interesting. Whoever voluntarily has carnal intercourse against the order of nature with a man, a woman, or animal. So in fact, it's not really same-sex relations. We are using this term today. It was actually non-procreative, penile, non-vaginal sex. So if I were to have penile oral sex with my female partner, or penile anal sex with my male or female or male partner, or any other penile non-vaginal interaction, that would actually be unnatural sex and would be punishable with transportation for life and imprisonment of either description up to 10 years and liable to a fine. So the most important thing was that it was criminalized. And prior to 1861, there was no criminalization of same-sex relations, as it were. And the important thing to remember is that in the explanation, like the explanation in rape under 375, penetration was sufficient to constitute carnal intercourse. Carnal intercourse meant sexual intercourse, and a carnal intercourse against the order of nature was penal non-vaginal. And interestingly, you can go to the next slide. Interestingly, transgender people were part of the culture of India. In fact, during the Suresh Kumar Kaushal's case in the Supreme Court, our Attorney General did a lot of research and found that a large number of gay men came to India in the beginning of the 19th century because they were escaping punishment in England, which actually had, punishment with death if a person was caught in an act of gross indecency, which was any kind of sexual relationship or buggery or sodomy. Now, because there are a large number of transgender people, or what we call hijras, etc., Arvanis and other groups, they were the people who were targeted by the British because they just couldn't stand them. And the first case after the Indian Penal Code was imposed was against Khairati, who was not caught in the act of unnatural sex, as it were, but was just a person who was cross-dressing and picked up, convicted by the lower court, the trial court. But in the High Court, they found that there was no case, because there was no act. But the discrimination and the stigma was so much brought about the British, though they had actually brought the law only recently at that time. Khairati was actually then acquitted in appeal. The point I'm trying to make is that the British law then brought about a culture in India which made Indians think. I'm sorry, my colleague's cat, which is roaming around, and she might throw herself out of the window. So I'm a bit worried. Thank you. Anyway, so after the Indian Penal Code in 1861 was imposed over a period of time, right up to, let's say, 2005-10, Indians started thinking this is part of our culture. In fact, I had a debate on television in Karan Thapar's show with Mr. Ravi Shankar Prasad ji, who was till recently the law minister of the present government. He challenged me that this is part of Indian culture and will never change it. And history has proven him wrong. But what he was actually emphasizing was the fact that Indians actually thought that this is a part of our culture. They didn't go into the history. And as I said, Khairati was the first person, a transgender person, who was convicted and then ultimately released on appeal. The other thing that happened was the transgender persons or hijras, they were also listed in the Criminal Tribes Act. The prejudice was so much on the part of the British that even till now, though the act has been repealed, even till now, if there's a robbery in some areas, transgender persons are picked up. Next. Now, what actually made us wake up, as it were, was the HIV scenario. We were very active in HIV, we still are. Our group, the Lawyers Collective, did the leading litigation on HIV, and we won a very important case, MX versus ZY in the Bombay High Court, which allowed gay men to come to our office because gay disease was considered to be an HIV disease. It was not true, but that is how the association was. And because of that, we were able to open up vistas to work with persons of the transgender groups, gay men, lesbians, bisexual, etc. And we actually realized that the root of all this evil was Section 377. Next. And because of that, HIV, there were a large number of groups starting to fund HIV work amongst men having sex with men or transgender persons. That's the first time we came to know what are the diseases which gay men are afflicted by. So these things actually allowed us to work with marginalized communities. And apart from the issues of gay men and persons having same-sex relations, we also able to work on issues of access to medicines. And then the famous Novartis case. Next. Now, ultimately, we filed a petition in the Delhi High Court. I don't have the time to go into why, but the important thing was we challenged 377. Like South Africa, we can challenge the validity constitutionally of a statute, and we challenged it on grounds of equality and equal protection of laws. Article 14, Article 15 is non-discrimination, and it had a particular expression, sex, which we argued included sexual orientation. Freedom of speech under Article 19. We argued that dressing itself is an expression of freedom of speech and expression. And Article 21, which was by that time already developed, and we included in that the question of privacy, the human dignity, and the right to health. Ultimately, NAS Foundation was decided by the Delhi High Court, and they read the section down to allow persons who had consensual sex in private, provided they were adults, they were allowed to not to be punished by under that section. So reading down was the actual mode of getting rid of the section, as it were. But if the person was non-consenting or not an adult, and if it was not in private, 377 even applies today. Next. In between, we also succeeded, and this is a point I wanted to make, in a university, Aligarh Muslim University, there was a professor whose home was raided by television journalists, and they caught him as it were red-handed with his lover, who was a person from the area and a different class background, but they wanted to humiliate him. But because NAS Foundation was already available, the action against him by the university in terms of employment was stayed. Therefore, in the employment scenario, because the university was a state institution, we could actually move against them. If it were a private institution, we would not have been able to move it unless there was a law. But unfortunately, he died a mysterious death, and that issue is a matter of subject matter of a very famous film, Aligarh, as you may know if you're in India. Next, ultimately, the matter was taken. The NAS Foundation matter was next. No, keep them. Was taken up in appeal in the Supreme Court, where we lost on a very ominous day. No, previous one, please. On an ominous day. Previous slide, please. Yeah, in Suresh Kumar Kaushal, that was the appeal against. The next slide, please. We lost out in Suresh Kumar Kaushal. It was a very badly written judgment based on prejudice. I don't want to go into the details of it, but they basically said homosexuals are a minuscule minority. HIV has got nothing to do with them. They are not being discriminated, etc. So we lost out on an ominous day, 11, 12, 13. We filed review petitions, then curative petitions. We didn't succeed. The curative petitions were actually held over until petitions were filed in Nafte Johar. In the meantime, we made a big success in the transgender issue in the judgment in the form of Nalsa, where we were able to argue that under the Indian, there is a long-standing tradition, as I mentioned earlier. A person can self-identify himself or herself as a woman, as a man, or a transgender person. That's what they had, because it was part of our dignity. Next. Next slide, please. Now, in the meantime, after Suresh Kumar Kaushal,
We lost you for a while, Anand.
Varsha madam, I think still there is a problem.
Yes, I
Internet issue.
think.
Yes. Can we drop message on phone?
We can. I will. He faced some technical glitch. Kindly give him a minute. He's joining from the other device. Kindly bear with us.
Okay, sure.
Yeah, he's joining. He's admitted to the panel. Yes, sir.
No,
Thank
sorry. I'm so sorry. This is happening quite a lot. Anyway, as I was saying, there were major landmarks between Kaushal and finally Navtej. One was the holding by the Supreme Court that privacy is a fundamental right in the Puttaswamy judgment. Then I've already talked about Nalsa, recognition of self-identification of the third gender or any gender. Then very important, rape law was actually changed in India. Originally, it was only confined to penile vaginal. All other acts were brought in, but it remained gender specific. Even till this day, only a man can rape a woman. Also, there was a change in the law relating to sexual assault amongst children, POCSO, Protection of Children Against Sexual Offences Act, that is gender neutral. There were change in mental health law, which included sexual orientation. And finally, the HIV Act came in, which actually recognized the gay community in terms of condom promotion in the context of HIV. Next. So, in fact, by the time Puttaswamy, Navtej Johar came, all the hurdles were already eliminated. So basically, they held what Nas Foundation had held. That's saying that carnal intercourse against the order of nature is not applicable in the case of consensual sex amongst adults in private. So that was the main thing. And they actually included in the challenge 19, freedom of speech and expression, unlike the Delhi High Court. Now, next, what are the future issues? One is the rape law. I don't know how much time I have. Right now,
4 minutes to go.
Okay, I'll just do it in 4 minutes. Right now, the rape law is gender specific. There's a strong need that there should be a gender neutrality in it, because transgender persons are being raped. Men are being raped by other men. Lesbians are being raped in courts, because we don't recognize that, by other women. And lots of cases are coming to us and going to court, not on rape, but a lot of cases are coming to lawyers where people within the community are sexually assaulting each other. And they don't have much recourse to law in terms of rape. So they actually go under 377 if they want to go. But nobody actually goes to court because they're afraid of being exposed, because they're living a cloistered life. They have not come out. The second issue, I don't want to get into the details, I don't have time. Just go 2 or 3 slides down the line. Go on. Yeah. Okay. No, go last slide. Yes. So the second issue is about marriage. In terms of marriage, there are a number of petitions filed in different high courts. In our system, each state has its own high court, and the Supreme Court is the final appellate court as well as an independent constitutional court. Now, same-sex marriage, the government is not interested in changing the law. They were not interested in changing the 377 either. So it will be actually, in my opinion, ultimately be decided by the courts. And in my opinion, the courts are bound to hold that same-sex marriages will be allowed. Issues about inheritance are very complex, because in India, inheritance is a matter of what is called personal law, applicable to one because of one's religion. And there the complications are that you have to take them each and challenge them. It'll be a very complicated and a messy affair. So therefore, it will need change in the law itself, which has to be done by Parliament. And I don't see them doing it in the near future. Most of the laws, except partially the Hindu laws, are very discriminatory against women. And there are very complex rules as to how much the woman gets as a inheritor, etc., etc. And amongst Muslims, there are issues about you cannot actually bequeath more than 2/3, etc. So there's a lot of issues which have to be dealt with, and they cannot be dealt with by courts. Therefore, they will have to be dealt with, if at all, by Parliament or state legislatures. Next. Okay, I think there was one slide I wanted to, if you can just go back. Yes. The Transgender Act deals with mostly discrimination. It is one of the acts, like the HIV Act, which allows for a person to go and access courts and take out an action on the basis of discrimination, even in the private sector, unlike all other laws. Because remember, as I mentioned to you earlier, the Constitution, the fundamental rights of equality under 14, 15, and 16 are only applicable to state institutions under Article 13. So if it's a private institution like NIRMA or like our group, Lawyers Collective, we can discriminate and they can't do anything in law. So in the Transgender Act and in the HIV Act, it has been made applicable even to private institutions. Unfortunately, recourse has not been taken to the Act in terms of private entities discriminating. The bigger issue in the Transgender Act has been self-identification. But unfortunately, the Act has not followed the law, and there are petitions challenging that in the Supreme Court. The rules have actually become much better. There they have changed and tuned it better, and we made a lot of representations in that. So I think the rules are much better than the Act, but there's an issue about whether the rules are intra vires. Healthcare, unfortunately, healthcare in India, despite COVID, is in a very bad state. We saw in the second wave of the COVID, the health system in India doesn't actually address the poor people's issues at all. And that's why despite the first wave giving us a warning, all of us went to sleep, mostly the government. They didn't put enough infrastructure in place to make sure people do have access to medicines and oxygen, etc. Large number of people died, and it's a sad story in my opinion. There are remedies under the Transgender Act, but it has not been used. So I'll stop here. I don't know if there are any questions, but if there are, I'll be happy to answer them.
Thank you so much, sir, for the insightful presentation. We will be taking questions at the end of all of the presentations. So now I would request Mr. Manvendra Singh Gohil to please address the audience.
Yeah, thank you, Shreya. It was wonderful listening to Megan, and I think are there between the two countries. And of course, Anand is a good friend of mine, and it was nice to get the historical background. And so my focus would be more sharing on my experiences as a LGBT rights and a human rights activist, and as a founder and chairperson of an organization called Lakshya Trust, which was the first organization in our state of Gujarat working for the men having sex with men and the transgender population. And based on that, I would kind of talk about the journey, what Anand spoke about, the laws which were initially filed and then which we won, and then we again lost, and then finally we won. So that whole journey of with the judicial system has gone through a lot of changes, and some good, some bad, and how we have overcome them, and how we have strategized the changes, and what is the way forward is something which I would like to talk about. So as Anand mentioned about the history part of it, I would like to add something about Indian culture. And like as he mentioned that this section 377 was not an Indian law, which was a law which was made during the colonial time. And historically, I mean, we have got so much of evidence in the form of statues, sculptures, paintings, texts, which has shown that homosexuality was part and parcel of the Indian culture. And if you talk about within the umbrella of the transgender, also specifically about the Hijra community, that was also a community which was actually, it's a very paradox situation in India that these Hijras are invited to bless a married couple, or they invited to bless a newborn child, especially a male child, and it's the same Hijras which we are subjecting them to stigma and discrimination, and violating their human rights on a day-to-day basis. So it's very unfortunate. If you talk about my own family, I mean, I belong to a 650-year-old dynasty, which is one of the oldest dynasties of India. And we have evidence in form of the Hijras, which the royal families have patronized. I mean, our royal courts had the presence of Hijras. We had Hijras also in the part of, a lot of decision making. I mean, they were even part of the cultural activities itself. So, they have been, part of our royal culture. And even like in my neighboring, place, with the city of Barodara, which is also a princely state, they have Hijras. I mean, that's a Gaikwad dynasty, and they have Hijras who named themselves Gaikwadi Hijras. So the royal families basically, had huge respect for this community, but it was unfortunate that this after Section 377 and these other, when they were made criminals, that this downfall of this community came about. Now, moving on, to 1990s, I would say. I mean, that's the time when HIV was taken seriously in our country. I mean, though it came into the country even much before the 1980s. And initially, as Anand mentioned, it was thought to be the name HIV also came in later on, but it was earlier called GRID, G-R-I-D, gay-related immunity disease. But then later on, they realized, no, it's not just the gay community, but the heterosexual community can be infected. And then the word HIV and AIDS came. But again, it's a very interesting to know that even though HIV was a curse to our society, but it came as a blessing in disguise when it came to organizations like mine, Lakshya Trust, Humsafar Trust, which is the first organization in India to work for the MSM and transgender. Why? Because the government felt the need that they need to support and partner with organizations like ours for HIV prevention and awareness. So on one hand, it was very, again, a very paradox and interesting situation. Like on one hand, the government supported and partnered with Lakshya, and that's how Lakshya started. In fact, the Lakshya Trust was founded in the year 2000, and it started with the government support. And as of now, also it is the government of Gujarat, our state government. 80% of our funding comes from the state government for HIV, issues, HIV prevention and awareness amongst the men having sex with men and the transgender community. And on the other hand, we've just heard about that there was a law in our country which was criminalizing the homosexual act. So that's something very interesting which has happened in India, and it kind of confuses a lot of when people outside of India come to our country, and it confuses a lot of them that how can you have the government support you and at the same time law says that treats you as criminals because of your act, your sexual act. But anyway, that was the situation. Now, as we heard from Anand about the Delhi High Court, legalizing decriminalizing the homosexual act first time in 2009. Before that, since I have been working on HIV and AIDS issues for a very long time, I have always felt that this law has been misused more than being used. And why I would say that is because even though we were a government-funded and partnered project, and Lakshya Trust working in the field of HIV and AIDS in the state of Gujarat, we have been subject to police harassment on a day-to-day basis. And I still remember, I had to go to the police station one day to get justice for our people. I mean, the police would just come to the public parks and the areas where we have these cruising sites, we call them, where men date other men, and they would just emotionally blackmail them, threaten them, exploit them, beat them up, and and threaten them with dire consequences that we will inform your parents and snatch their mobile phones. And just because our staff was distributing condoms in the public parks and trying to create awareness about HIV, the police has dealt with so much of violence. Not just that, I remember once even some of our staff members have been arrested, beaten up, arrested, taken to jail, and the police have had forced sex with my staff. They have raped my staff members and without condoms. So now you tell me, who are the criminals? Are we the criminals who are distributing condoms under a government-funded project for creating awareness about HIV? Or are the police the criminals who are kind of misusing the law, and the only reason they are saying is that you all are violating Section 377. I mean, distribution of condom was interpreted as violating Section 377, and you all are promoting homosexuality. That was the reason given, and I had to go to the police station and get my staff released. So just imagine that the kind of humiliation and we had to face at the hands of the police. So therefore it was important for us to get rid of this law, because even I remember the NACO, National AIDS Control Organization, which is the highest authority in India who is to fund us, our projects and all. They also had made a statement that this law is an impediment to HIV control in the country. So therefore, it was very important from the HIV point of view that this law had to be amended. Now, the judgment in 2009 of the Delhi High Court did bring a little bit of relief was seen when which was for a short-lived period, but between the period of 2009 and 2013, when again we lost the case when in the Supreme Court, there was a bit of a relief was experienced in the community, because especially a lot of them who wanted to come out, they made the courage of coming out and talking about their issues, and especially to their parents, and some of the parents also started accepting them. So there was some kind of a change was found, and then because of the fact of this police cases coming up, and we ultimately did patch up with the police. I mean, because fortunately ours was a government funded project, so it was a bit easy for us to kind of reach out to the police department, and we kind of started educating the police. We realized that, see, police is not at fault as such. I mean, police or anyone who has done anything against us is not at fault. It is their ignorance on the subject which needs to be addressed. And because we know of the fact that in India, unfortunately, in spite of, I always quote this, in spite of the fact that India is a land of Kama Sutra, the world's oldest sex encyclopedia, yet the basic sex education is not taught in our education system. So forget about how are they going to learn about issues about being LGBT and MSM and transgenders is absolutely missing in our education system. So we kind of started addressing the police issues, and we joined the Friends of Police Association. And on now, I would say that we have identified gay men within the police department. Police is fully supporting us now, and they take part in our events. And so many things have happened. Many positive things have also happened. So, so that was of course, short-lived. But then, in 2013, again, when we lost the case in the Supreme Court, there was a lot of disappointment, not just from the community, but a lot of allies, a lot of people who are supporting us then. I think in the 2013, when the judgment came against us, we got more support from allies. And when I say allies, that means the parents and families and a lot of other people who are connected with us, media and Bollywood, and a lot of change was seen even when we lost. So then, of course, in between we had this time when the transgender the rights were recognized by the Nalsa judgment in Supreme Court. It happened in 2014. That, of course, was quite unexpected thing to happen. And I remember I was in the day this judgment came, I had just landed at New York airport, that when the judgment had arrived, and I was literally flocked by the media at the airport. And there was this one question which the media was asking: how did your country even recognize the transgender rights when America is still struggling with it? And and in spite of the fact that we lost a case in the Supreme Court, how did the transgender rights come about? So that was a lot of questions in the minds of people, that how this happened. But anyway, that happened. And but I must tell you one thing which happened before this judgment came in the year 2013. That time the Congress government was in ruling, not the present party which was ruling. That time there was a roundtable conference which was organized in New Delhi by the Ministry of Social Justice and Empowerment, and I was fortunate to be invited for that roundtable conference, and along with my other trans members of the trans community, I had gone for that meeting, and there were a lot of discussions which happened in that meeting too, and that meeting led to the Nalsa judgment happening in 2014. So that happened in 2014. Now again, like as Anand mentioned, the activists, the community did not lose hope, and then this putative petition was filed in the Supreme Court, and again a lot of people started joining in this petition, and it was the parents who joined. Now, fortunately, in India, we have an organization which is started by the parents. We call it the Rainbow Parents Association. It's also called SWIKAR, which is consisting of mothers, fathers, grandparents, uncles, aunts, many of them. It's very similar to what PFLAG is in America, Parents and Friends of Lesbians and Gays. Now, this organization SWIKAR is an Indian word which means acceptance. And this SWIKAR also joined hands, and a lot of they started doing a lot of counseling for mothers, like mothers talking to other mothers and all. Even the mental health practitioners, they started supporting, and they also joined hands. So a lot of changes were seen post 2014. Between 2014 to 2018, Bollywood started changing its position. In fact, I remember as a kid, I used to watch a lot of Bollywood films in which we were just treated as jokers, just like, as if we are some comical characters, and, they would show some very, stereotypes, like, we are effeminate, and we are like pansy, and that kind of characters, And then Bollywood started taking up very serious roles, and, talking about many other issues, talking about HIV issues, talking about, there was a beautiful film which came out, which talked about the wives of gay men. Because in India, you have to realize most of us are married to women, So they started talking about that. And even our organization, Lakshya Trust, was one of the first organizations in India to have done a study on the wives of gay men.
Mr. Gohil, may I please request you to wind it up in a minute?
Yeah, sure. So, I would like to conclude by saying that 2014 to 2018, a lot of changes happened. Post 2018, after the judgment came, of course, there was a jubilation, there was celebration. Many things have happened after 2018. But again, as Anand has pointed out, and many of us feel that this law, Section 377, has not brought about major change, as we see. Even though there is a law in place now, within our constitutional rights have been restored back, but still a lot of issues need to be tackled about, like we talked about marriage issues, the inheritance issues. But one thing good which happened, which I would like to talk about, is that the Ministry of Social Justice and Empowerment has granted transgender shelter homes in India, which has never happened before. It's the first time that it happened, and my organization, Lakshya Trust, was the first organization in India to have been granted a transgender shelter home, which not just provides shelter and food, but it also is trying to build the skills of the trans community and see how they could be employed, self-employed, empowered, so that they could be financially independent. So I think that was one of the positive things which have happened, and still we have to achieve a lot. We have to, and I always I have a famous quote which I like to make, is that gay rights are human rights, and it cannot be just won in the courtrooms, but in the hearts and the minds of the people we live with. Thank you very much.
Thank you so much, sir. And your experience really counts for all of us in understanding the issues faced by the community and the lived realities of the community. I would now request Professor Anup Singh to please offer his observations and comments on today's technical session. Sir, could you please address the audience?
Thank you. First of all, I'd like to congratulate both, Nirma University Law School and Johannesburg Law School for coming closer and opening a new platform. The topic of today is very relevant because it shows that how society changes and how society develop certain advantages and disadvantages. So this whole topic of this topic has been such where we have made some progress, but we have also, lost some ground. And it is because of our human ability not to understand other humans. We human beings are very complex beings. And one fundamental problem that we get is our received knowledge. We learn from our seniors, our forefathers, what is right and what is not right without analyzing the facts. But as new knowledge is coming, we understand that new ways of humans are emerging, and we need to be more scientific in our approach. One thing which is very clear here, that look, scientifically, humans can be quite complex in their sexual orientation, and therefore we need to fight our own prejudices and stereotypes. One major problem in implementation of law is that we are not able to overcome our own prejudices and stereotypes. So when we are not able to control our own prejudices and stereotypes, then we behave in a very conservative and non-scientific fashion. So the real need of our is we develop a scientific mindset and an egalitarian mindset. Of course, law and social orientation would play a very important role in that. So my suggestion to students is that they are law students and they need to look into law, but at the same time they need to look into stupidity and the restrictions of human intelligence, and they need to work to develop a more scientific and more humanitarian orientation. Only then we would be able to create a healthier society. So these are some of my observations. Thank you.
Thank you so much, sir. I would now request Ms. Ropa to provide her observations on the session today.
Thank you so much, Shreya. And thank you so much to all of our speakers. I think all your discussions were very insightful, and I think we can all agree that we've learned a lot from your presentations today. From my observations, I think it's quite clear that there are a number of similarities between the South African jurisdiction and the Indian jurisdiction, and also the way that our courts in South Africa approach LGBTQ matters and the way that the Supreme Court of India has done as well. Firstly, I find it very interesting that, with the criminalization of same-sex relations, this is a burden that we inherited both countries from our colonial periods. And it is a problem that now we continue to face in terms of trying to deal with societal attitudes and the hate that this particular community continues to face. Megan, I really appreciate the way that you tried to, or rather actually drew from the role that the law plays as a tool for societal change. And I think this is where some of my questions actually stem from, because we notice this disjuncture between legislative measures and court decisions and the actual lived realities of the LGBTQ plus community. And I think Mr. Grover and Mr. Gohill also pointed out that despite the decisions to decriminalize same-sex relations, the reality on the ground does not actually reflect what our courts are trying to show or trying to teach our communities. So this brings up for me the concept of public morality versus, constitutional morality. And Megan, I think you touched on this, and was also reiterated in the Delhi High Court decision in 2009, when the court decriminalized consensual same-sex relations. And it was again emphasized by the Nafti Johar judgment following, the Poteswami judgment. And the court really raised the role that public morality arguments play in terms of keeping restrictive laws in place. And we see in the National Coalition case in South Africa, the court had to balance the harm suffered by homosexual persons against the moral views of the community. And the court found that most of the moral views that the public holds are nothing more than prejudice. And yet these are the same views that are used to, restrict the rights of members of the LGBTQ+ community. And similar to the decisions in India, the South African Constitutional Court found that public moral arguments do not qualify as a legitimate purpose for the criminalization of homosexuality. And the court also acknowledged the existence of religious opinions regarding sexual relations, but found that while South Africa supports the freedom of religion, the state cannot use these religious views to regulate all religions. So my question really, Megan, to you is, where there is a lack of public support for LGBTQ+ protections, how should courts affirm constitutional morality versus public morality?
Should I answer that now?
Yes.
Very, very happy to. Well, that's a really fantastic question. So, where there is an absence of public support and we have these extensive array of legal protections, at least on paper, what is really the role of the courts? And I suppose, I guess I have two things to say to that. The first thing that I would say is that, of course, I think courts should continue to hold the line, and that although there is this disjuncture between the legal victories and lived realities, that does not mean that the legal victories are entirely pyrrhic or useless. So it's still really, really important for the court to continue to uphold these protections and to allow litigants, LGBTQI+ litigants, to vindicate their rights and their remedies. However, the second part to my answer would be, ultimately, I think what part of this reveals is that the courts in particular, as broad public and social actors, are limited. Some of the change that needs to happen has to happen not only on a policy level, but is really ultimately not just a legal question, but more a sociological and political question. And so, we can see the courts really holding the line and affirming rights, which is really, really important, and sometimes even creating remedies that go beyond just a bare court order, but say mandate meaningful engagement within communities. And that's one way in which I guess courts can shift things. At the same time, ultimately, I think we also need to be modest about the extent to which this change can only be driven through legal processes.
Thank you so much, Megan. I think there are many other parallels to draw from the two jurisdictions, particularly the relying on other rights, when adjudicating or deciding to decriminalize homosexuality. I think I could go on about the different parallels between the two jurisdictions, but for the sake of time, I'm going to hand over to Shreya, so maybe we can open up questions to our audience as well.
Thank you, Rupa. So a question that we would like Mr. Grover to address. So if you could shed some light, I believe we lost connection with him. Meanwhile, if I could address the question to Mr. Manvendra Gohil. Sir, if you could explain to us what kind of strategies can be used to bring about a change in the parliamentary will when it comes to granting of family rights to the members of the LGBTQI community?
See, I have always believed in doing advocacy at all levels. So political advocacy is also important, and that's something which we've been talking a great about whenever we are having forums, and we've been coming together as a network. And let me also tell you that India, we are fortunate that we have a huge network of sexual minority. It's a registered society which has been, I'm one of the founding members of it. It's called INFOSEM, Integrated Network for Sexual Minorities, which has got more than 160 registered organizations working on the different sexual minority communities. So as a network, we many times we have addressed a lot of issues, and one of the important issues, the political advocacy issues with, and since we are present in all the states, practically all states of India, we have some representation or the other. We make it a point to talk to our political leaders, our representatives from the legislative assembly, from the members of the parliament, on whichever party is in, we are friendly with, to do this advocacy to see how we can bring about the change. And I myself have done a lot of political advocacy with the members of parliaments and in the various parties, and we need to create allies. It's important to create allies amongst all political parties. It's not just the ruling party or the opposition party. We have to see. I always believe we have to work with the party in power. And if somebody asks me which party you belong to, I said I'm absolutely neutral. I'm very apolitical. I'm a person who would favor or support an individual and not a party. And that individual can be from any party. If any individual supports me, I'll support that individual. So that's how I've been doing political advocacy, and we have have some achievements in hand, and I think that's the best way to go about it.
Thank you so much, sir, for that enlightening answer. We have another very interesting question, and I would like Mr. Grover to address this question. A student of ours wants to know that how do you think the queer phobia that was brought about by colonialism and has been internalized as part of our culture can be eradicated? And is it evident that education isn't really much of a help, and considering that a lot of educated people also are queer phobic? So what can really bring about positive change?
Well, I'll answer that by giving you exactly what we did during the case that we ran from 2001 to 2018. The NAS Foundation case was launched in 2001, but we started working on it in 1998 because I did a very big case on HIV. And for the first time in 1998, the Bombay High Court ruled that an HIV positive person can be hired in a state entity. And that case, MX versus ZY, as I told you, is associated with gay disease. Gay disease was HIV disease at that time. So a lot of gay people came to our office, and everybody complained about blackmail. Their partners, the police, their families, and initially we couldn't actually locate the evil, as it were, and ultimately we located it in terms of Section 377. Now I know that a lot of you are trying to differentiate between the so-called lived experience and the law, but in this case, were it not for the fact that 377 actually goes, there would not be any question of any lived experience, because that meant that everybody was closeted. I mean, when we started the case and we were looking for a petitioner, and because it was pro bono, I could do that. Otherwise, lawyers are not allowed to do that. We couldn't find anybody who was openly willing to come and say he's gay and fight the case, except my good friend Ashok Rao Kavi. I didn't know Manavendra Goyal that, but I don't know whether he'll look back and say, I would have done it. But by the time it ended in 2018, I think you'll all know that everybody was jumping over each other to be a petitioner. That was the change which happened between 2001 and 2018. What happened was we learned a very big thing in the HIV scenario. I used to go all around the place, colleges, establishments, factories, and talk to everybody about HIV, and invariably sex used to come in. And we would talk to mothers, daughters, everybody, and say, look, this is, they would say it's gay people who are doing it. So we would ask them, what do you mean by gay sex? Is it penile, oral, penile, vaginal, this, that, the other? And condoms is the best way of going about it. So there was open talk about sex, not only in the institutions, but even in courts, and ultimately it landed up in the media. The media played a very, very important role, and we used the media to actually reach the homes of people where mothers, as Manavendra mentioned, mothers would talk about the fact that their children are gay or their daughter is lesbian or what have you. And these things were coming into your home and people were talking about that. That actually made a big change. And I think we have achieved the victory because of that big change. And I don't agree with people that things have not changed. I will tell you another thing. And so we continue to do that even after we filed the petition. That's why the media took it up. And the media was very good. And ultimately, even the ruling party, Congress was slightly more favorable. BJP was not, but even BJP changed. And I agree with Manavendra. I don't care which party you belong to. My job is to change your thinking on a particular issue. And I'll go to anybody to change their point of view, because I believe in the just cause, as it were. But I'll just tell you another experience I've had. I've been doing webinars. I got a call from a young lady. I didn't know how old she was. She said, please do a webinar for our group, and there'll be 150 people. And we want you to talk about 377. Of course, I had an hour to talk and I could go into detail. But, on the day I asked her, when the webinar was to happen, just before the webinar, I asked her, what is the age group of this audience? You know what she told me? 13 to 18. And they were willing to listen about 377, about sexual practices. So don't ever get this that young people don't know. They know more about it than you do, and I do. And that is the actual level of change. At this level, they are willing, they're thirsty for knowledge. They want to know, and now they want me to do a seminar or webinar for Bhima Koregaon cases, which I'm doing. So they want to know about UAPA. They want to know about those cases. Why are people put in jail? Why are people put in jail? Because they are protesting about Citizenship Amendment Act. They want to know that, So they are thirsty for knowledge about everything. The next generation won't think like this. In the next 20 years, it won't be the same thought. Politicians will remain like that because they are aiming at vote banks, and people think in the way they think they should be thinking. Now, I'll give you another example. We did Shashi Tharoor and I did a moot parliament for young people. During the question hour, there was a young boy. His head barely came above the stage. Must have been 8 or 9 years old. And he told me a very interesting thing. He said, my parents belong to a political party. It's conservative. I don't want to name names. And they don't agree with me, but I think 377 should be abolished. Okay? So these are young people who are thinking differently from their parents. That's normal. So I think the change is already happening. It will continue to happen, especially in the LGBTQI areas, because young people don't think the way older people have thought in the past. Thank you.
Thank you so much, sir, for that insightful answer and the positive outlook that we are developing slowly towards the concerns that are raised by the LGBTQI community. Due to paucity of time, we will not be able to take further questions. However, this is a larger dialogue and we can interact with each other on other platforms as well. I would now request Professor Ganguly to offer the vote of thanks for the session.
Thank you, Shreya. At the end of the inaugural session and this first webinar, which has just been getting over, I would like to thank, and I take this opportunity for the acknowledgement and thanking each and every person who have made this event a success. To begin with, Professor Singh, our DG sir, Dr. Parikh, our Director and Dean in charge, Professor Toit, and Professor Domingo from University of Johannesburg to inaugurate the occasion and provided us very inspirational and supportive voices. Special thanks to the speakers, Ms. Megan Finn, Mr. Anand Grover, and Mr. Manvendra Singh Gohil. I would also like to thank Professor Elmari along with me, who provided an overview. Special thanks to Professor MPD and Professor Pokharial as pioneering anchors and facilitators of this collaboration project. And I would like to give special thanks to both Shreya and MS Shreya Srivastava and MS Rupa Fanzo for being discussant and also anchoring the entire event until now. I would also like to give special thanks to Megan Feen and Professor Elmari from UJ for being, actively coordinating the event until now, and to our technical team, and special reference to special mention of as our assistant registrar, Mr. Gagandeep Khanduja, and technical assistant team, and the TRAs at ILNU, and all the participants for bearing with us for little late start and the technical glitches that we faced. But you kindly bear with us, and thank you for the same. And I like to thank you all the colleagues at Nirma University and University of Johannesburg for making this academic endeavor a success. Thank you all. And we take 10 minutes break for after this, and then we start the second webinar on
I believe 5
Yeah,
minutes is
5 minutes is
something we
fine.
can
Yeah,
afford right
sure.
now. Yes.
Sure. So we meet after 5 minutes. Thank you all again.
Good afternoon, everyone, and welcome back to the second segment of our seminar today. We are now going to be having new speakers joining us, and they will be commenting on the commitments to the CEDAW, that is the Convention on the Elimination of Discrimination Against Women. Today, we've got two speakers that will be tackling these issues, and I'm honored to be introducing them to you. The first speaker is Ms. Leonie van der Merwe. She is a lecturer at the University of Johannesburg, and she has delivered measurable successes working alongside South Africa's most decorated professionals as a legal and governance professional, and also as a company secretary. She holds LLB and LLM degrees from the University of Johannesburg and the University of South Africa, respectively. As I've mentioned, she's currently employed as a lecturer at the Faculty of Law at UJ, where she teaches business law, labor law, and law of succession to both law and non-law students. Leonie plays the role of change agent in numerous capacities in the broader community, and her main research focus relates to persons with disabilities and other vulnerable persons in society. Our second speaker today, you've already become acquainted with, is Ms. Shreya, who is an assistant professor and at the Institute of Law at Nima University. Shreya teaches family law and gender justice and feminist jurisprudence. She is currently pursuing her doctoral studies from the Gujarat National Law University on relationships in nature of marriage, in which a comparative study between India and the United Kingdom is undertaken. Her areas of interest are family law and women's rights, around which her scholarship also revolves. You can tell that we really have experts on this particular topic today, and we look forward to hearing from both of you on your presentations. Leonie, over to you.
Thank you, Ropa. Good afternoon. I think I can say good afternoon to everybody. We are all in the afternoon in terms of our time slots. I'm Leonie van der Merwe from the Faculty of Law, and my research is entitled Of Faux Pas and Low-Hanging Fruit, an assessment of South Africa's compliance with CEDAW in the age of COVID. So before we get started, I think it's important that I also share a trigger warning before I get started with my presentation. While CEDAW, or the Convention of Elimination of Discrimination Against all forms with regard to women, does deal with many aspects such as education and housing, living arrangements, political life, I will be focusing to a large extent. The scope of my research is limited only to issues of violence pertaining to women, as this has come to the fore since we went into our lockdown. So before we get started, this is my research. In part one, we'll be looking at our introduction, and we'll set out our constitutional framework as well. We will then also look at understanding the prevalence of violence against women and in the world at large, as well as in South Africa. And we will be assessing the intersection between COVID-19 and violence against women. Secondly, we'll move over to our qualitative analysis. We will actually dive into CEDAW, and we'll look at CEDAW from a South African perspective. We'll look at a few of the articles within CEDAW as the central international instrument that forms part of this research. And then in part three, I will put forward some of my recommendations based on this research, and that will tie into Shreya's presentation, and it will allow us then to draw analogies and synergies between the two territories. So before we get started, my details are up on the screen should you wish to collaborate, or if you have any constructive criticism that you'd like to make available. In recent years, social media movements such as #MeToo, #HeForShe, #OrangeTheWorld, and #NiUnaMenos have shed light on the superfluity of issues facing women. Globally, women face issues such as gender-based violence, harassment, gender inequality, and the like. So we've seen all of this happen, especially in the last 3 years within our society globally, where women have taken a central role with regard to activism. And what I'm saying is that based on the research and based on what we see, the precarious position of the South African woman is no different to what is happening globally. So in 2020, the Commission for Gender Equality, in its annual report that it delivers, noted in unacceptably high levels of gender-based violence as well as inequality in private and public sectors across various socio-economic groups within society. And as we all know, during March of 2020, South Africa went into a lockdown. And what this lockdown essentially then did was it turned homes throughout South Africa into enclaves or havens or catalysts for violence against women. And so in speaking about this, it's important to also then speak about CEDAW, right, as the main international instrument that regulates human rights issues amongst women. Informally, CEDAW is known as the Women's Human Rights Bill. And this particular piece of international convention was established in 1979. And this particular convention is known as the most comprehensive convention relating to women's rights in the world. So when assessing South Africa's compliance with CEDAW during COVID, this might provide us with insight so that we can pragmatically and practically improve the lived experiences of South African women on the ground. So we move, as Megan was saying earlier, we move beyond policy proliferation, and then what we do is we actually start changing the lived experiences of women and what we see in society as a result of patriarchal systems, as a result of misogyny, as a result of various ills that in 1995. So this was right after our democracy. And what essentially then happened was it then also acceded to the optional protocol that is attached to CEDAW much later on in 2005. So with India in mind, and I'll always draw this common thread of India in this presentation, because we are very alike, the two territories, but we also have fundamental differences. And with India in mind, this research serves as the starting point to develop synergies and parallels with other territories where CEDAW has been applied on a much larger scale. So looking at pluralism and also looking at how we essentially deal with matters that relate to women, I think India would be the perfect vantage point for South Africa to learn a few lessons with regard to violence against women, given that these mechanisms in India have been implemented on a much larger scale. Also, with regard to the motivation for this research, the research conducted is rooted in the prevalence of violence experienced by women. So while there is a large body of research that is available with regard to the violence that women face, adding the COVID-19 element and viewing the research through the lens of COVID, because we now have many women who are abused or women who experience violence who are now sharing homes with their abusers permanently as a result of the various regulations issued by the state in this regard. And as I said previously, it is important to note that a lot of the research in this particular body of research of mine relates mostly to sexual assault and other types of violence against women. But I will touch on matters such as education and the like. So up on the screen, the infographic just depicts the prevalence of violence against women as set out by the Women's Branch of the United Nations. And so the statistic, and this is before COVID, the statistic is very scary. 1 in 3 women will experience violence within their lifetimes at the hands of most times an intimate partner, and in other instances, other persons in society as well. So up on the screen, I've just chosen a few news clippings, and these essentially from about March last year to the current date are our front of house or front of mind articles that deal with women who have succumbed to gross violations in terms of CEDAW. And up on the screen, we can see, I think the most recent one has to do with one of our university students at the University of Fort Hare being murdered by her boyfriend and her body being dismembered. And so these kind of things, both in India and South Africa, have become par for the course. And what then happens is that the more we see these articles in the media and the more we have activism and public outcry, the feeling on the ground is that at this particular point in time, the government needs to come to the party, while although we have all these amazing policies as well as initiatives, especially in the recent wake of all of these matters that are up on the screen, we need to move beyond the point of policy drafting and proliferation of policies, and we need to move towards actually implementing these international instruments as well as regional and national pieces of legislation. So to speak a bit about the framework that I'm going to be using in this session, right at the top, we have our constitution, and you'll see that the constitution would be the golden thread with regard to violence against women in South Africa. And GBV, sexual assault, and all of those things have a direct bearing on human dignity as stated in the Constitution, equality. And it also is important in the sense that in many, many instances, the right to life is also at play when dealing with the prevalence of violence against women within South Africa. So the aim of this study is to shed light on what South Africa's obligations are in terms of CEDAW, how it has performed in terms of those obligations. And I think it's also important to remember that gender-based violence in the definition as set out by the United Nations is very, very broad. And in this particular instance, it doesn't only refer to physical abuse and physical harassment, it could also refer to emotional and mental issues. And so in doing so, I think it's also important when looking at our constitutional and legislative framework, it is important for us to also then look at national legislation that has been enacted. So we have the constitution sitting up at the top, by use of an analogy, the constitution would be the roof of the house. And each of the rooms within the house would then be pieces of legislation that are very, very important to make sure that that roof of the house stays intact, and that we also make sure that we don't breach our constitutional imperatives, and that we don't use the constitution in a way that it actually infringes upon the rights of women across the world. So what's important is at the center, as I said, we have our constitution. We also have the Domestic Violence Act of 1998. And this particular act provides just a bit of relief for domestic violence victims, and it sets out the structures that need to be followed so as to make sure that we meet our objectives in terms of CEDAW. And there are also new pieces of legislation in the pipeline in South Africa. And these pieces of legislation from about Feb in 2021, so February early this year, to the current moment, what happened was, as a result of the public outcry relating to what has happened to women in South Africa specifically, the president then convened a summit to discuss gender-based violence. And as a result of that summit, we have 3 bills that sat before the National Assembly. And these bills seek to bring about reprieve for our victims of violence, being women mostly in society. And the first one would be your Criminal and Related Matters Amendment Act. This particular bill will revisit our National Register for Sexual Offences, and it will look at how we can streamline all of these registers that exist in pockets and in silos across South African society. The second bill is the Domestic Violence Amendment Bill, and this particular bill addresses how certain functionaries, how certain office bearers within South African society need to handle domestic violence matters. And then the third piece of legislation that was also passed by the National Assembly is our Criminal Law, Sexual Offences and Related Matters Amendment Act. And this provides for the creation of an intermediary service when evidence is provided in court. So making sure that there's a middleman if we are providing sensitive evidence that the victim isn't further victimized. And when we are dealing with girl children, that in those particular instances, they feel free to speak to an intermediary about their experience, as well as making sure that their evidence is sound and that they are free to give evidence. And then that would again feed in to our constitution sitting up top as the roof of this house that we are trying to build so as to strengthen our approach to gender-based violence and the likes. So with regard to CEDAW, This particular part of my presentation will look at certain articles within CEDAW. As I said, some articles I will refer to in more depth than others, and some articles become slightly superfluous due to the abundance of research that has been developed to discuss particular articles within CEDAW. Right, so when having a look at Articles 1 and 2, the primary focus of Articles 1 and 2 of CEDAW look at eliminating and defining discrimination. So our South African scholars that are in this call and around will now know that this speaks directly to Section 9 in our Constitution, also known as our Equality Clause. It places an onus on...
Ms. Leonie, sorry to interrupt. Can you please wind up in 2 minutes?
I'll do that, thank you. So this particular article then places an emphasis on South Africa, making sure that it eliminates discrimination, and that ties into Section 9 of the Constitution. Article 3 of the same international convention looks at the advancement of women in society. And here we identified that there's been ineffective mainstreaming and there have been policy gaps and there's a lack of accountability. Article 5 speaks to sex roles and stereotypes. And this, my main area of concern with regard to this article is that legal transformation within South Africa is not driven by the state, and there's been inadequate implementation with regard to particular articles. Article 6 then looks at suppressing child trafficking and trafficking of women, as well as the exploitation of women. So this looks at our sex workers as well. And then Article 7 and onwards respectively look at education. And you would all know that with regard to COVID, it's changed the face of education in our country. So many girl children are in fact housed with their abusers during school time. And Articles 11, 12, 13, and 14 then deal with employment, health, economic and social life, and the precarious position of rural women or women in rural areas. So to conclude, in this particular body of research, what I have concluded is that high levels of violence impact the right to be free from discrimination. That will always be in the periphery. GBV victims struggle to obtain assistance in society, whether it is from the courts, whether it is from law enforcement. And many women in South Africa and the world over do not know that this international instrument, CEDAW, actually exists. And another interesting thing about South Africa is that a lot of our reporting that we need to make in respect of the committee for CEDAW is in effect very late periodically. So that also plays a very important role in making sure that we meet our international law obligations. And what's also important is that we understand that there are certain policy gaps where there is misalignment between the courts and parliament, and how this will be corrected. We will have to then look at other jurisdictions such as India, and we will then have to see what they have utilized. So the points raised by the author demonstrate that while policy formulation in South Africa is robust, as Megan has alluded to earlier, an additional oversight body is perhaps required to ensure that implementation, transparency, and accountability are present in a manner that transcends mere policy formation, but also actively makes COVID and CEDAW an alignment between those two. So make sure that CEDAW becomes a household name in various places within South Africa, from rural to urban areas. And it also makes sure that we enforce the notion that we do not just protect persons theoretically, but that we also make sure that our policies, our laws that are brought into place also just transcend those theoretical frameworks. And what we have up on the screen, we have a woman. So this is a cartoon from International Women's Day, and the woman is carrying the weight of all of her problems on her shoulders. And she then has femicide, inequality, sexual abuse, misogyny, human trafficking, single parents, votes for women. And these are all issues that CEDAW has sought to eradicate and to mitigate. And so what remains to be seen is whether we could rely on the takes of jurisdictions such as India to be able to make available mechanisms where we can improve the practically lived experiences of women in South Africa going forward. Thank you.
Thank you so much, Leonie. I think you just gave us such a beautiful analysis of the CEDAW and also the South African statutory framework. I look forward to hear what Shreya's presentation is about in regard to similar factors in the Indian context. Shreya, you may proceed with your presentation. Thank you.
Thank you so much, Rupa. And thank you, Ms. Merve, for your very insightful and thorough presentation. And I hope I am able to complement your presentation with what I will be speaking on today. I will just take a minute to maximize the size of my presentation. I hope the screen is visible to everybody.
It is, thank you.
Thank you so much, Rupa. So today I'll be speaking about CEDAW and the commitments of India, visibilizing the invisibles. And the scheme of my presentation is, because CEDAW is a huge document, and as it suggests, it's elimination of all forms of discrimination against women. So I will be restricting myself to violence against women. And in India, I'll be analyzing it from the perspective of 3 laws: the Protection of Women from Domestic Violence Act, the POSH Act, which deals with sexual harassment at the workplace, prevention, protection, and redressal, and lastly, the IPC with focus on rape as a crime. I'm sorry, I'm trying to navigate my presentation, just 1 minute. Right. So, according to the 2011 census, in India, females constitute 48.46% of the population. So that's nearly 50% of the population is of women. And India signed the convention in July 1980, on 30th July precisely, and it ratified it in the year 1993 on 9th of July. Now, I would, at the cost of repetition to what Ms. Merve said, it is the Women's Convention. And because it is speaking about all forms of discrimination against women, it is a women's human rights convention. It guarantees women the equal recognition, enjoyment, and exercise of all human rights and fundamental freedoms in the political, economic, social, cultural, civil, domestic, or any other field. And this is irrespective of the status that they have, that be it a marital status, be it that of a status of divorce or widowhood. And the idea is to bring about an equality with men through this convention. The obligations of state parties under CEDAW are threefold. First of all, that the state parties must ensure that there is no direct or indirect discrimination against women in their laws, and that women are protected against all forms of discrimination. Secondly, state parties must ensure that there is no direct or indirect discrimination against the laws that are present in the country. And lastly, the parties must ensure that gender relations and the persistence of gender-based stereotypes that will affect women through individual acts, through law and legal and social structures, as well as institutions, are brought about at parity with that of the rights that are and the perceptions that are present with respect to the other members of the society. Now, if I speak about why we need to ensure that violence against women is dealt with, and I speak from the perspective of the Indian Constitution, then what we have come to understand through the jurisprudence that has been developed by the courts in India is that a purely formalistic legal approach will not suffice to achieve the goals of the convention. So we have older case laws that have, for instance, Anuj Garg versus Hotel Association, where we looked at the rights of women from a very formalistic equality approach. And that over the years we have understood cannot achieve the purposes, the true the true idea of equality that the Convention, the Constitution of India strive for? So the answer lies in ensuring substantive equality. And the subsequent jurisprudence that we have developed in India with respect to rights of women revolves around substantive equality. That is, we need to understand that women have faced patriarchal biases historically. And it is these patriarchal biases that have existed and have gotten ingrained in our attitudes, in our perspectives for so long that we need to destabilize and we need to break down these biases. So that is the idea of substantive equality. And if we read judgments of the Supreme Court of the later times, such as Joseph Shine, we understand that we are slowly but steadily, we are moving towards substantive equality. Now, under the convention, all countries are supposed to submit their periodic reports. It's done on a cycle basis. And India has submitted until now 5 periodic reports, which started from the year 1998, and the last was submitted in the year 2013. And through an analysis of these periodic reports, we understand that there has been a slow but steady improvement in the elimination of discrimination against women in the different areas that the convention covers. Now, this is a very optimistic statement. However, like I said, the improvement is slow. So every time we have received suggestions from the CEDAW, from the United Nations, on how to further improve the condition of women in the society. And it is the work that we have done until now and the suggestions that we have received that I'm going to be speaking about in the coming few slides. Now, violence against women, and I would like to quote some data here so that we understand the gravity of the situation. And I borrow this data from the National Family Health Survey, which is a survey carried out by the Government of India, as well as the National Crime Records Bureau, again, an authentic source of the crimes committed in India. There has been a stark increase in violent crimes against women, especially rape and abduction, and it indicates an increase by 902.1% between 1971 and 2012. Domestic violence, if we talk about, then 37% of ever married women, that is 15 years and above, and this is also 15 years to 49 years, they have experienced partner violence, and 30.9% of all of these violences were committed against women by their husbands. Rape cases in India are 32,000. In the year. If I talk about, if we increase the age limit here, it seems to be missing. This is 15 to 49 years. If we increase the age limit from over 49 years, we'll understand that domestic violence cases might even be more than what has been reported here. So the percentage would even be more than 37%. So now, with this statistical background in mind, I come to the first law that I would like to talk about, Protection of Women from the Domestic Violence Act 2005. A study was conducted in the year 2014 by the United Nations Population Fund with the International Center for Research on Women. And it has stated that 60% of men reported using some form of violence. And this form of violence ranged from physical to economic, emotional, and even sexual against their wife or partner. And while we might tend to think that physical violence is a violence that that is very prevalent, what the study indicates is that 41% of men admitted committing emotional violence upon their wives or their partners. Again, if I go back to data, I want to highlight here that though it is 60% of men have committed violence, but it is only 31% of women who have reported the violence that they have faced. So there is still a stark difference between what is the violence that is being committed and the violence that is being reported. And even within this 31%, 75% women have not sought help from any of their reliable sources, be it their families, natal families, be it their friends, be it the police. They haven't sought any help and they have chosen to live with the violent partner in the relationship. Similarly, only 1.5% of women have gone to the police to complain about cases of only severe violence. And how do we define severe violence is a very subjective definition. So there is, there is no clear-cut answer of what severe violence is. Now, the Protection of Women from Domestic Violence Act provides for certain intermediaries in the structure that it has set up. These intermediaries involve police officers, service providers, shelter homes, and protection officers. And all of these intermediaries exist in order to facilitate the woman to be able to get a remedy under the said act. But like I highlighted, these intermediate, the structure that has been set up has not been tapped into by the women, and most of them have not used the structures that are available in the act. At the same time, it is not, the condition is also that the structures are also not very effective. So we do not have protection officers in every district. Shelter homes, for instance, and I will come to this point, that shelter homes do not take women all the time when they approach them. The condition in shelter homes is grave, and it is unfortunate. And sometimes some of you would have followed the news that in these shelter homes, sexual violence is committed against the persons who are residing there. So the analysis needs to be as to what kind of intermediaries we are providing, what kind of services, quality services are they providing. If I talk about the shadow pandemic, that is the domestic violence and COVID-19, then violence escalates in mobility of survivor and abuse. And with COVID-19 came another sort of pandemic in the country, which was that of domestic violence. Constant surveillance, control of movements and actions led to violation of privacy and increased instances of violence against women. Digital divide was reduced the access to support that was available to women. So many poor women were not able to access the services that are provided by the statute. And there had been reported increased levels of physical, emotional, sexual, and economic abuse. Women who were working from home, another kind of burden that they faced was that of the double burden of housework as well as office work. And another unique kind of violence that women faced during this time was that their husbands or their partners refused to follow COVID-19 protocols. So Swayam, that is an organization which works in the field of women's rights, has received cases where women complained that their husbands or their partners used to go out of their homes without wearing masks, come back and still want to have intercourse with their wives. And this put women at great mental and physical stress. Mental health issues, of course, increased. And what is reported is that helplines were being used more for getting mental health relief than any other kind of than the other kinds of reliefs. And as I was saying earlier, shelter homes did not take new survivors because they were already full, and because of the COVID restrictions, shelter homes were hesitant to take more survivors. So when it comes to this private space of the home, what kind of way forward should we envision, especially in such times? First of all, we should have standard operating procedures. Now, when the lockdown was announced, there was no standard operating procedure for shelter homes, for helplines, for courts, for organizations working for civil society organizations. There was no standard operating procedure. So that needs to be taken care of anytime in the future. We have now come to realize that digital platforms can be extensively and effectively used. We have so many, doctors reached out on WhatsApp. We had so many groups that were formed. We had small snippets and movies that were used to create awareness, both against violence against women as well as COVID-19. So digital platforms must continue to be used even in the future. Helplines should remain active. Now, this was the biggest problem that we faced. Helplines weren't active. Many women tried to call 181 and the other helplines, state helplines that were created, but to no avail. So this is something that we have to, as a society, and the government has to ensure that helplines remain active during this period. And the most important thing is upskilling of service providers like counselors and civil society organizations. Now, during the pandemic, training was given to counselors on how to interact with survivors over phone, because face-to-face interaction is different from a telephonic interaction or an interaction over a message. So that kind of upskilling must constantly be there, and we must not stop here thinking that we've dealt with the situation, because this is going to stay for some time. So that upskilling must constantly be there. Now, this is what I have to say about the Protection of Women from Domestic Violence Act. Another area that I would like to talk about, that was the private space and the violence in the private space. I now want to speak about violence against women in the public space. And here I would like to focus on the offense of rape under the federal statute of the country. We have, and as you must have heard in Mr. Grover's presentation also, that we used to have a very restrictive definition of the offense of rape. But with the Criminal Law Amendment Act 2013, we expanded the definition. We gave a comprehensive definition to the offense that was created. And also new offenses such as voyeurism, stalking, sexual harassment, and asset attacks have been included. Now, from 2013 to 2018, we had unfortunate instances in the country, such as the Katwa rape case. And because of that, another amendment was brought about in the year 2018, and special provisions of grave punishment to the extent of life imprisonment or death have been included with respect to rape of minors. Now, while we have done this, when we last submitted our report to the UN, what we were also suggested was that we need to bring about a parity in our laws in terms of girl children, because they are an important part of the society. Now, here I would like to highlight what India did after submitting its report. So 2013 is when the amendment came, 2014 is when we submitted the report, and thereafter suggestions were received. Now, after that, what we have done is the Supreme Court of India passed a judgment called Independent Thought versus Union of India. And this is a very positive judgment because it brings about a change in the reading of the law, and it has held that sexual intercourse between a man and his wife, being a girl between the ages of 15 and 18 years, is rape. Until the decision of Independent Thought, the offense did not exist. So while we have recognized rape, marital rape, in cases of girl children who are between the ages of 15 and 18 years, marital rape as an offense generally continues to be an exception and is not recognized in the Indian statutory framework. And of course, there is conversation going on in 2013. The J.S. Verma committee suggested it, but we are yet to reach that stage where we accept marital rape as an offense. And in light of the recent developments, it becomes utmost essential that we have this as an offense. And also, a report that I would like to highlight here is that of the Special Rapporteur on Violence Against Women in 2014, who have called on to the government to remove the exception of marital rape and define it as a marital offense. So this was again a suggestion that we had received after our cycle of 2014 reporting, but we still need to introduce this amendment. And the last statute that I would like to speak about is the Sexual Harassment of Women at the Workplace, Prevention, Prohibition and Redressal Act 2013. Now, after much conversation, we had this statute that was passed in the year 2013, and it was again well appreciated when we filed our periodic report. The test of sexual harassment that has been laid down under this act is whether the conduct was unreasonable and unwelcome to the recipient. Now, it broadens the definition. So it gives a very wide definition of what will amount to sexual harassment. It could be direct or by implication. It could be physical contact, advances, demand or request for sexual favors, sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. It also includes forms that lead to quid pro quo or hostile work environment. So all of the forms of sexual harassment that have been recognized will fall either under the quid pro quo sexual harassment or hostile work environment kind of a sexual harassment. And the provisions of the Act are so framed that it provides speedy redressal for instances of sexual harassment at the workplace. And the infrastructures that have been set up under the Act are that of an internal complaints committee at the organizational level. We also have the local complaints committee at the district level. So we have a thorough infrastructure in place. Now, certain developments, and these can again be related to what the United Nations had suggested to India. When we had submitted the report, what we had in place was the Suresh Kumar Kaushal judgment, wherein we had not recognized homosexual consensual behavior. And the suggestion at that point of time was to reverse the judgment of Suresh Kumar Kaushal. Now, in 2018, we had Navteej Johar, and we recognized consensual sexual behavior. Because gender and gender identity is also an important part of CEDAW. We recently, in the year 2021, had a Calcutta High Court judgment called Dr. Malavika Chatterjee versus Internal Complaints Committee, Vivekanand College and others. And this judgment is in keeping with the vision that CEDAW has, with the vision that United Nations has. It recognizes that sexual harassment is not a static concept, and acts of sexual harassment complained of can be perpetrated by members of any gender, even intersex. So here, members of the same gender had committed acts of sexual violence. One of them had committed the act of sexual violence against the other, and this was recognized under the POSH Act, wherein even though the act was passed because sexual harassment has been considered to be a gendered offense against women by men, in spite of that, we have such a progressive judgment. So it speaks about the way forward that we are going, and in a positive, and the sensitization. Many organizations and many people are unaware of their rights. So
Ms. Shreya, sorry to interrupt. Kindly conclude in a minute, please.
Yes, definitely. So constant upskilling of the members of the Internal Complaints Committee, which has been set up, is required. Now, often Internal Complaints Committee members are not aware of judgments that have taken place. They might be aware of the processes. They might not be aware of the judgments. They're not aware of how to use the evidences objectively and mindfully and logically. So these are the kind of upskilling activities that need to be provided to the members of the ICC. And also the dynamics of gender at work and in general must be informed to them. So the way forward here is to sensitize. And that's how we will be able to truly achieve the objectives of the POSH Act. With this, I would like to end my presentation, and I believe we can now open the floor for discussions and questions and answers. Thank you so much.
Thank you so much, Shreya. That was truly insightful in terms of the Indian context and how, the Indian government or the Indian state is making steps towards preventing or responding to the increasing number of GBV cases in the country. I think what stands out to me is really the number of steps that the Indian state has taken over the years to reform rape laws. As you've pointed out, for example, extending the definition of rape and introducing, new forms of sexual offenses. This is quite similar to what we see in the South African context as well, because it was only just a couple of years ago when we also outlawed marital rape and said this is actually a criminal offense. So I think there are very similar steps being taken in both jurisdictions. And I think it's also interesting that both you and Leonie touched on the way that GBV cases have increased during lockdown. And I wonder whether this was something to do with implementation of the law, or whether policy proliferation, as Leonie put it, is really the problem. And I'm going to ask about that in a minute, but I just wanted to also just, touch on the different types of ways that states are trying to implement changes. And in this regard, I actually have a question for you, Shreya, if you don't mind to begin in this regard. I see that, there was a particularly interesting case that I followed from the Indian context, the Nibaya case. If you remember, this was the case where a physiotherapy student was gang raped and murdered. And there was quite a large public outcry following that particular incident. And I think that was when the Criminal Law Amendment Act of 2013 was introduced in India, redefining rape and introducing harsher forms of punishment. Now, Leonie also mentioned the gender-based violence bills that are being introduced in South Africa. And while they do not call for the death penalty the way that the Criminal Law Amendment Act of 2013 does in India, we see that one of the bills in South Africa, which is the Criminal and Related Matters Amendment Bill, seeks to introduce stricter bail conditions and harsher minimum sentences. So my question here is really, how feasible is it to propose endeavors that seek to introduce harsher punishments? Is this effective at all in response to violence against women, or is this just another case of policy proliferation? If you'd like to respond to that.
Thank you, Rupa, for the question. So I believe that harsher punishments can act as a deterrent, but will they really? Because, I mean, law, this is the school of thought that I come from. Law should be the last resort. The first thing that we need to begin with is a social understanding, a change at the grassroots level in the mindsets of the people, and an understanding of what the issue is. So if we are able to deal with that, then I'm sure that, you know, even the harsher punishments will help in reducing the instances, but there is no guarantee. I personally believe that there is no guarantee that with harsher punishments, we will have lesser instances.
Thank you so much, Shreya. And before we open up the Q&A to the audience as well, I just want to touch on Leonie's analysis of the CEDAW. And Leonie, with the increase of GBV cases during the pandemic, I think it is safe to say that certain groups of women have been more exposed to violence than others, because women experience discrimination based on their sex and gender, but this is also linked to other identities, factors, and experiences, such as culture and poverty. And we see from the CEDAW that there are no specific provisions that recognize women's intersectional identity. And due to the silence from the convention, CEDAW has been accused of not protecting intersectional discrimination. So my question to you, Leonie, is how does the CEDAW approach mutually reinforcing forms of discrimination, such as racism, classism, and also heterosexism?
That's an excellent question. Thank you. I think what is important is that we also just remember that this whole concept of intersectionality and the way it has come about in society, specifically in the last 3 or so years, has led to a lot of people doing the activism in their respective communities. And I think that that is one of the net effects of CEDAW, in that even though it doesn't specifically deal with the concept of intersectionality as developed in Chicago in the 70s, what it has in fact done is it has then allowed for members of the public to push that particular agenda. So I just want to tie that into a question in the chat from Kushal, and he's asking about legal transformation and how legal, my comment was that legal transformation isn't necessarily driven by the state. And what I mean by that is our legislation, our constitution, we need to remember that those are aspirational documents. And there is always going to be practical implementation that needs to take place with regard to those particular pieces of legislation, as well as the constitution. So what then happens is that in a society where you find that there's a lag with how the state is rolling out particular mechanisms to combat GBV and assault against women and violence and all of those things, what happens, as we've now seen with COVID in the last few months and lockdowns, is that the citizens and members of the public take that legal transformation into their own hands. And we see that not only with women, but we see it with other vulnerable groups in society as well. Persons with disabilities, people who act for children because they can't obviously act for themselves. So that is what I mean by that. So to answer your question, Rupa, that mechanism is dealt with by people in those respective states. But I do agree that in future, the United Nations and the whole body of international law, they're going to have to look at mechanisms to take into consideration that intersectionality, because we are robust, diverse individuals. And that, again, goes back to the issue of pluralism. Yeah.
Thank you so much, Leonie. One final question from the chat, and I think, Shreya, you can answer this if you're happy to. The question requires you to comment on how epistemic violence that individuals face in the form of forced disruption and transformation of one's belief systems and ideology or demand for conformity can be incorporated into the scope of interpreting domestic violence, which in most cases is limited to physical and psychological violence. Thank you, Shreya.
Thank you, Ropa. I believe you've addressed this question to me. So, yes. And this is asked by my colleague, Dr. Vinny. So I feel that as of now, our understanding of domestic violence in terms of the law that we have in place is limited to the extent of physical, emotional, sexual, and mental. While such a situation can be put within the ambit of emotional violence or mental violence, it can very well be put there by a expansion of the term. But the question is, how far is our judiciary or the legislative framework ready to bring about that change? That will, at the moment, seems to not be there in the country. And that is something that needs larger conversation to be, so that such a change can be brought about and must be brought about, because belief is something personal to a person and is essential for one's identity. So I think we need to bring about that change. But as of now, we can only hope that if such a case comes, then our judiciary is wise enough to broaden the law as it exists right now.
Thank you so much, Shreya. Thank you. And thank you to you both you and Leonie, for your amazing presentations. Thank you so much for your analysis of both the jurisdictions in the Indian and South African context. And thank you to our attendees as well for being patient with us as we are running behind time a little. Thank you so much for that. I would now like to hand over to Prof. Elmarie-Fourie to give us our vote of thanks.
Thank you so much, Ropa. What a wonderful start to our seminar series. And it's clear that we can spend the whole day engaging with these topics, and people are really engaging, and it's wonderful. A special word of thanks to Prof. Singh, Dr. Parekh, Prof. Tutui, and Prof. Domingo for contributing to our very, very important collaboration. I also want to thank Prof. Varsha and Megan and all colleagues involved in making this a reality. Thank you. This is much appreciated. To the technical team, thank you for making this a seamless online webinar. And then a special word of thanks to all our presenters. What wonderful presentations. You engaged with such important societal issues, and you highlighted the importance of this and provided valuable insights. That is so much appreciated. And our two discussants, Ropa, Shreya, you did such a great job today. And for everyone engaging, I'm so proud today to be part of this collaboration. Thank you, everyone. I hope you have, well, I suppose it's evening in India. I hope you have a wonderful evening and an afternoon. And I'm really looking forward to our next seminar. Thank you to everyone joining us here today. It is much appreciated. Good evening and good afternoon, ladies and gentlemen.
Thank you so much.
Thank you, everyone. See you soon.
Thank you, everyone. Stay safe. Have a great day and good weekend.
Stay safe.